The school board work session begins in 1 minute. Please take your seats. Again, the school board work session begins in 1 minute.
Good morning. I now call the February 16th, 2022 Administrative Briefing and Work Session of the Marion County School Board to order at 9 o'clock a.m. Please silence your electronic devices and remove hats to avoid disturbing others. I'll now ask the school board attorney to explain the rules of this work session.
This work session is a public meeting as defined in Florida's Sunshine Law. The board is dedicated to full transparency in its meetings and its work. In compliance with the Sunshine Law, the board has adopted uniform meeting procedures, including the right for citizens to participate. The board will allow public comment regarding any work session item listed on today's agenda at the appropriate time. Speakers must fill out a request form located in the lobby and hand it to the school board clerk. After the board and superintendent have completed their discussion on a particular agenda item, the clerk will call speakers' names in the order received. At the podium, speakers are asked to state their full name and address and to spell their last names. Each speaker will have 3 minutes. As required by the Sunshine Law, the board must maintain orderly conduct and proper decorum throughout this meeting. Speakers may criticize subject matter and decisions in a respectful manner, but not people. Finally, speakers must be very careful not to violate the privacy rights of others, especially students and their family members, by mentioning their names or other identifying information. Thank you for your attention to these important rules.
Thank you, Attorney. We will now begin the work session in the continuation of the NEOLA policy review. Good morning, everyone. We going to take the lead from Attorney Powers and bring us up to speed where we were at and where we're moving forward to.
Yes, sir. In your review books, there is a list on page 1, but it's the third page within your books, which is the work session topics listed for today. And starting with policy PO 1214, solicitation or acceptance of gifts or unauthorized compensation. Now, before we get into that, these are the final policies that have edits that have been made by staff for this session. We will also be addressing in our March sessions, we'll be addressing bylaws as well as any remaining edits which are not completed, or any remaining items which are not completed today from this list, and any which we decide to send back to staff for further revision, or which staff brings forward for further revision. Now, in the case of ones that the board has already completed, looked over, that have had suggested staff edits, of course, at that point, the board, they'd need permission of the board to propose those edits, and so they would then bring those back in March if they have any updates that they wish to propose to the board. So we can get through as many as we can with this list today. And this is the sum total of what we have listed here, starting with PO 1214 and ending all the way with PO 9800 in charter schools. So Mr. Whitmer, Tom Whitmer from NEOLA, is here as well. And I'll ask if he has any updates or introductions that he would like to start with before we move into the first policy.
No, I'd just like to thank Terry for putting it all together in such a readable format, easy to find.
All right.
Thank you, Terry. Yay.
Thank you.
Nobody's here to clap for you, but we'll clap.
Thank you.
Terry rocks.
All right, we will start with PO 1214, which is solicitation or acceptance of gifts or authorized compensations.
Looks good to me.
And this is one that staff edited.
Yes.
Yep. Yeah, I'm good.
And you can see from the strikes what the edits are there, so we can just go down the list each one, and I'll give it that appropriate wait time if anybody has anything they wish to add. If not, we'll move on to the next one.
Let's roll.
Okay, likewise, PO 3214 and PO 4214, these are mirror policies for other sections regarding the same topics, solicitation or acceptance of gifts or unauthorized compensation for each of the others as well. So 4214 is as to support staff. 3214 is as to instructional staff, and the staff has reviewed each of these items and proposes acceptance of the edits that you see there.
And just as a matter of question, I hate to go back to the original one because Terry's like clicking buttons, but 1214 does say, in addition, instructional staff members who recommend purchases. I just want to make sure that we do want to have the word instructional staff members in the policy about administrative staff. That was back in policy 1214. I'm sorry. I know that you just we're clicking around.
It's that green paragraph right there.
And the answer may be yes, but I just,
Well,
And which,
I do too want to go back to that one, because I'm looking at something that's, I think should be consistent all the way across. So go ahead and deal with that one, and I'll as soon as you get through, I'll address this.
we're pulling up 1214 right now. It's now on your screen.
it's in the green section, so it's towards the bottom.
It may be the same thing I'm looking at.
Right there, the in addition instructional staff members who recommend purchases, this is the policy for administrative staff members, so I'm not sure if those words need to say administrative in both of those sections.
This one's still not working, so
It's in the administrative one, yeah.
is that what you're, I can oversee that.
I take it.
It's
out.
on
I think
page 2 in your
doesn't-
notebook, too.
It's in the instructions.
Or-
Same with the next green paragraph.
You want to say
Actually,
it's administrative?
No, that next paragraph,
I would suggest that we alter that to
Administrative.
administrative there, and Mr. Whitmer concurs.
That's fine, yes.
And
the next paragraph,
the paragraph that is
Okay,
two paragraphs
that's what we're
below
looking at.
that also says any instructional staff member. And in that case, because of the nature of that
should be
statement, I think
any
we should just
staff.
say any staff member.
correct.
That's fine.
And that needs to go to the next one, because that same edit needs to be made in the next one as well. Any staff, not just instructional. And I think the other one says any non-instructional
Okay,
needs to be corrected.
So that phrase we'll make sure is consistent for all three policies.
Right.
And then
Correct.
as to each of the three policies, it will reference in the paragraph that says, in addition, administrative staff will also say the appropriate staff for that policy section. So you want to make those, this
It's
is
already-
correct.
It's
as-
already correct in the
Yeah, this can-
3,000, yeah.
this is,
All
I'm
right,
fine
and
with the way that's worded if you guys are.
Okay, so the same alterations in each of those other two.
They're already done.
Policies,
It's
they're already done?
already-
Okay, thank you.
I'm okay.
Look at 3214. And the reason I'm saying look at 3214, because it's not something that we had already revised. All the way to the end.
Okay. 3214 is now on your screen.
All the way to the end.
What page is that?
006.
Thank you.
If you look at the bottom right-hand corner, these
Right
are
there.
bait
Right
stamped
there,
with
Terry.
SBA 005
Any instructional,
and 006 for the page numbers.
any instructional staff member,
The paragraph just above the green section. So remove the word
that-
instructional.
Right.
right,
So on this one, let's remove where it says instructional, right there. Yep.
Right.
Yep.
So any staff member who has knowledge of,
right.
okay? And then, unless you have anything else on that one, we'll move forward and check the same on 4214.
Right, that's good.
Wait. Go back to that one.
Was there another issue?
Nope, that's it.
I have to move this.
That's correct. I'm good with it. I'm sorry. Thank you. And it should be the same thing, same edit in 4214.
4214, yep. Good catch,
Take out support.
which is page 008.
Okay, 4214 is now on your screen. And that is page numbers SBA 007 and 008 as bait stamped in your copy. And then we're striking the word support under any support, so it says any staff member who has knowledge of.
Perfect.
And that would be all. Next items up are anti-harassment policies. This is 1362, 3362, and 4362. Now, I have a note here. These policies, after being reviewed by the board and decided on, there were additional staff edits which were submitted yesterday. These would be significant edits because although much of the content would likely not change, it's been suggested that we mirror actually identical policy for all three, is what staff has indicated. However, we need to go through each of those items, or staff would need to go through each of those items to ensure that they truly are identical. In other words, 1362, the suggestion by staff was to copy and paste that exact policy throughout 3362 and 4362, along with using PO 5517 to incorporate. Now, that hasn't been completed by staff. That was the suggestion, so I said, given that it was submitted yesterday, that we would need to have staff complete that process and bring it back before the board for us to review. Since the board has already looked at it, made their edits and decisions on it, and now there's another item to change, I would prefer that we not take the time right now to try to alter it in a way without staff having reviewed all of the input to make sure that it's exact. I believe that's the best use of the board's time.
Yes, sir.
When you say staff, is that superintendent?
It would be one of the superintendent staff. In this case, it'd be Ms. Gary.
Her designees.
I couldn't.
It would be the superintendent staff. In this case, it'd be Ms. Gary. And Ms. Gary is, she serves as,
Bless you.
she does items related to Title IX, diversity, coordination. I mean, there's a lot. I will stumble if I try to outline all of the details of her job title.
I got it.
But she's the person who has to interact with a lot of these policies on a daily basis. So she's, in looking them over again, she had some suggestions based on what we had done, but those suggestions haven't been finalized. I guess that's the appropriate way to put it.
Thank you, Chair. Yes, agreed. So, and there have been some changes that have come recently from Title IX, so we make sure that we have all of those correctly stated in our language here.
So that being said, we will table those and come back to them at our next review session.
Okay.
Moving on to our next sections on terminal pay. That is policies 1420.01 and the mirror policies of 3420.01 and 4420.01.
48. Page
What is that?
48?
What does it show as a page?
Page 48?
648.
No, there's just page 48.
Oh, 48. Got it.
Yeah, I pulled out my table of contents so in front of me. I don't know if that would be helpful for you guys too, but.
Okay, so that's, as she indicated, page 48, SBA 048 in your bottom right-hand corner, date stamped. As to terminal pay 1420.01, this first section appears to be global terminal pay. Then as to 3420, the first one is administrative personnel. 3420 is instructional personnel. And 4420 is support personnel. And those are the policies as reviewed and edits made by staff.
This is probably a question for Dr. Gullett, but in this policy, it's specifically striking hire date anniversary, and we're replacing the words hire date anniversary with years of experience. So I guess Ms. Oliver or her team has corrected that based on maybe the terminology we use for that. I'm not certain the difference. I guess we're not doing hire date anniversaries any longer, but we're doing it based on years of experience. I don't know what the difference in those two are, but
It leaves it kind of cloudy to
it
me.
does leave it pretty cloudy. And so
Years of experience, I mean, what if you count the years of experience before they were working in the district?
right.
Are you going to bring that forward as well? So-
And
'Cause-
experience in
right.
what?
I may suggest that years of experience would include someone who had an interruption in service but then restarted again, as opposed to
So they had a break in
questioning
service.
initial hire date versus secondary hiring date, or
So they had a break in service. So
that could be one example.
it's just kind of cloudy to me.
Yes.
I'm not, I don't, when I read this, I don't understand.
Years of experience, how we're calculating years of experience, and if there is a definition somewhere, and I don't know that there is, but if there's a definition somewhere in policy about what years of experience means, then I'm okay with leaving it that way, but otherwise,
Right. And hire date, for example, in my current position, if I were a teacher and then I stopped
Right.
teaching, went to law school, came back and was hired as a school board attorney.
Right.
My hire date, if you use either of my hire dates, it's an improper, it doesn't truly capture years of experience for certain items. So
Right.
that could be just one area that it would impact, and I'm sure there would be others, other examples, but I don't know the answer to the difference between hire date and anniversary, hire date anniversary and years of experience, or if there's an additional way to clarify. It's just as it was submitted by staff.
well, as this has come back from staff, I'm sure they have a reason for it. I'm checking. Sure, no, I'm
yeah.
certain that you are. Just, I think,
Yeah.
I don't know if we want to wait on that answer, or if we want to.
No, we can keep
I'm
moving.
Keep moving.
comfortable. I'm sure there's a reason, and maybe we
Yeah.
could just ask,
Right.
and then clarify. I don't see us
not moving forward
Right.
with that because of that. That's my opinion.
Right.
I'm
I
sure.
agree.
And so what are you saying?
I'm
It'll come
saying-
back at a,
No, I just think there's probably a reasonable answer to this, years of experience, you know, we're not in there living it and breathing it, and I think JC could probably address it,
Right.
you know, later. I don't see us debating why it's
No.
there and holding it, putting
No.
a hold on it. I think we should just,
Come back to it, maybe?
Yes.
maybe not
just hear what
debate
the
it,
answer
but
is, and I'm sure she can explain it. I just,
could we make a shot at just, superintendent perhaps, make a shot at describing it to clarify it some? And I'd feel more comfortable.
I think that's what we're waiting on, to get an answer from.
yeah,
And
maybe
I-
she could
I
just
agree-
send us
checking
an
with Ms.
email.
Oliver.
Yeah, I agree that we should not get stuck here. We got a
Correct.
lot to go forward.
Right.
I don't
And
mean
soon
get
as-
stuck,
Soon
but
as we get the answer, she's
We'll come
already,
back.
she's already requested the clarity on it, and once she gets clarity on it, we'll come back to it.
Yeah, okay.
Yeah.
Okay, good.
Yeah.
Oh, got it, thank
Yeah.
you.
Thank you.
So as of right now, we're not making any alterations, and when Dr. Gullett hears back from
Right.
Ms. Oliver, then we'll readdress
to it.
Yeah,
these three.
okay, got it, that's today, got it.
Do we want to also look at each of the other two policies to see if there's any additional concerns that she might address now?
It looks like because these are Marion policies, they've just copied and pasted exactly the information from so it's the same question. So once we get that question answered, I think that's the only question about that one. I don't know if you guys have other questions.
Okay.
All right.
Moving on to 1430, leaves of absence, and the mirror policies 3430 and 4430.
Page 53.
That's page 53 in your booklet. Starting with 1430, leaves of absence.
Mr. Powers?
Yes, sir.
I just on the last subject, they were talking about the years of experience versus hire date. In the statute on sick leave, it does refer to years of service. That's just the terminology used during the first 3 years, during and after the 12th year of service, whatever. So I think maybe they're trying to just be more
Aligned with statute.
similar to the statute, yeah.
Does the statute also define what years of service means?
No, I don't see that.
Okay. Then they need to be clearer in how it's written. Under that item C there, is that supposed to be, is it personal charge to sick or personnel charge to sick?
Personal, it's personal as in personal leave.
Personal leave charged to the sick, okay, sorry, I'm just not reading that grammatically the way I thought.
Where is it at?
Item C, if you can scroll down just a bit, Terry. C, superintendent is authorized to approve the following types of administrator leave. Personal. And I understand it now, but whenever I was reading it, I'm like, okay, vacation, sick leave, personal charge. Can it be personal leave charged to sick?
I think that would make it clearer.
Can we change item C if you guys would be, just to say personal leave? It was right there.
Yeah, I like that.
Personal leave charged to sick, just because personal charge to sick doesn't
It's not
Grammatically.
feel right.
grammatically correct.
Yeah,
And you probably want to add personal leave charge to sick leave.
sure.
I like that.
I agree with that.
There we go.
Yeah. I'm fine with that, with those changes, unless there's, oh, there, yeah, good job.
I am as well.
She knew it needed to be changed somewhere else, so she's going to fix that. Thanks, Terry. I think you might know these policies backwards and forwards by now.
Additionally, I will note that that one of the edits in this policy is intended to address a situation that we have with the resolution which will be coming before the board, and that is regarding the proper fix for us to be able to allow for authorization by the superintendent for extended leave, or not extended leave, I gotta be careful about the language that I use, for unpaid leave for COVID-related emergencies, for example, which is something that we address in the resolution. If you notice that in the green, the very first edit on 1430, you can see that what's been inserted there. Previously, this said, "A leave of absence is permission granted or allowed by the school board under its adopted policies." This now would indicate superintendent or school board.
Good.
Talk about that.
Right.
I'm fine with that, with those edits.
Okay.
And
Any
then-
other edits? And the edits that we're talking about making to personal leave, charge to sick leave, those, we're going to mirror those edits in each of the other two policies as well.
Perfect.
Aside from that, in 1420, are there any additional concerns, edits, anything to make?
These-
Okay.
Yeah.
And we'll just do the same thing on 3430, if you want to put eyes on that one, just to make sure that there's nothing different that you would like to have altered, other than what we just discussed with 1430.
I do got a question, and I guess it's on through all three of these leave policies. On that first, it's the first page of it, an employee being on leave for part or all of 2 consecutive school years. Was it must? I thought we talked about that, must return to work for.
And this was specifically added by staff, so it
For
may
a
be-
fully year.
Are you? Yeah, that one's in policy 4430. I'd see there is a Y that needs to be
It's a
removed
Y,
there.
L-Y. And then, was it,
Let me make sure I'm on
was
the
the
same.
word must? Thought we talked about trying to give some discretion to.
Tell me the edit you were just referring to, Reverend
Page
Cummings.
57 in our books.
Okay,
It's correct in the other two policies, but in this one, it says employee being on
For
leave
a fully year, I see.
Right, there's a Y that needs to be removed.
it's,
4430?
yes, and 4430,
Okay, wait, I gotta look at-
But the word must is your question, which
Right.
would be carried over to all of them.
Right. Did we say must? I thought we were trying to kind of give some leeway. I can't remember how we were talking about it.
see where it says fully
'Cause that's
year?
kind of
Right.
where we are with the
For
current
a-
policy.
Should be full.
Well, it seems to me, and
There you go.
this is just me thinking out loud, that if an employee is going to be on leave for an extended period of time, at some point, it goes into FMLA.
Correct.
And so I think what this is saying, unless the employee is eligible for FMLA, then, FMLA kicks in at some point. This is if they're not eligible for FMLA. And so we're asking that they have to be able to work for a full year without taking another leave that doesn't kick over into FMLA. And I'm not certain how long the leave can be before it goes into FMLA. Is it before 8 weeks or 12 weeks
I think you get like so many weeks every year.
of personal leave?
Of FMLA. You're only eligible for, it's a certain amount of FMLA that you get every year, and then it has to renew, has to reset.
Right.
I don't know. I could be maybe I'm just seeing that must, and it's That's just kind of sending a red flag to me. I'm not sure.
Well, this is, I guess, if they're on leave for 2 consecutive school years.
And it says they must come back and work another year before they have leave again.
So let's have,
So if they come back, let's say you are out, you had a baby.
I know, I was thinking if you had a baby in every year,
Right.
but having a baby most likely would put you out on FMLA. So this is not going to
Impact.
impact you because you would not be a part of,
If the child had complications and you still out,
that's still FMLA. I mean, most likely.
but that doesn't say that.
I know, there's,
Yeah, I'm more for being clear
right.
with certain things so that we kind of move some of that gray area out of the policies where where one person will do one thing, another person will do something else. We need these policies to be as consistent as possible when it comes to everything.
Well, I may be wrong, but I think what they mean is when the employee is on leave for part or all, what happens is, say an employee is ill and they hold that position. So while they're gone, they hold that. But I think this is a way of maybe protecting the district in the sense that when they, if they can't come back for whatever the reason is, then that position opens and it can be filled with somebody, that could probably fill it. And so I'm pretty confident that that's why that is in there.
And that would be in year 3, because we're not talking about in your first year or your second year. This is in
Right.
year 3, if this is
The third year.
the 3rd year that you're taking an extended leave.
Right, well, it says for part or all of 2 consecutive years, so then it would, so I think that's there.
Well, they would be, and they would be covered possibly for FMLA in the 3rd year.
Right.
So,
Maybe, yeah,
I'm okay with it. I don't,
yeah, I'm fine with it, I just,
I'm good.
Okay, so then.
Wait a minute, wait. So let me give you another scenario.
okay.
Okay, let me read it again. And I'm just trying to make it make sense. An employee being on leave for part or all of 2 consecutive school years must return to work for a full year before being awarded another leave of absence, unless the employee is eligible for military leave or FMLA in the 3rd year. I get where the FMLA comes in, but what if the FMLA is gone? Because there's only so much FMLA that you can get.
right, but at some point,
I mean, we can't
there
hold the
needs
job
to
forever.
be, you can't, right, so for example, you have, I'm just gonna say, you're in a school, there's a 3rd grade teacher, you need to fill that position, but you cannot fill that position until that person is not there, if we're holding
Correct.
it. And so, in essence, I mean, I think 2 is fair, I'm sure there's reasons for that, but to protect, the students or the district, at some point, you need to do what's best for our students or district, and, I mean, that's my thoughts, if that makes sense.
because that means
It's-
that classroom would have a sub for all of
Correct.
those years, because we know that we're short.
Correct. And
But that's if they're out for the whole year. This says part of. So what if one year I had to take leave for a medical issue, another year I had to take leave for another medical issue, and it exhausted those times? Are we through with me? What if I had cancer treatment, chemo, whatever?
Well, then, most likely in the 3rd year, if this
Is
is,
it going to fall under FMLA?
FMLA
Right.
would be implicated in
Yeah.
that.
So, okay, I'm
Even
just,
before the 3rd year.
FMLA would
Right.
cover that.
okay, that's what I just want to be clear on it. I know we're not going to hold, I don't think we should hold a position forever and ever and ever.
Yeah.
But I just want to make sure that we're not just kicking them to the curb.
No, I don't think we're kicking them to the curb, but in some ways it sounds harsh, but at some point there probably
Right.
needs to be an executive decision to do what's right and best for
Right.
the student or district. I mean, that's my opinion. You may think
And
differently.
I share it.
I share it with Ms. King.
Yeah. Okay, I'm good. I just wanted clarity on it.
Please tell me this isn't also covered in the sick leave policy. Maybe it is. that we're
So
about to
we reviewed 1430, 3430, and 4430.
Yes.
Let me just verify we've made the edits to 3340 on the paid leave, personal leave and sick leave, adding the term leave.
I did.
Okay. All right.
And, no, I just.
Any additional concerns or edits before we move on?
Leaves
Okay.
of absence, we're moving that one. Okay.
Seeing none, sick leave, that is 1430.03, 3430.03, and the final mirror policy 4430.03. Those begin on page 59 of your handout. And there is a note that there are some formatting things to be fixed here, and that's just a function of how it shows within the program versus how it's typed in. NEOLA makes those fixes during their cleaning. Any formatting errors, it's like an A or an extra 1 or something like that. It's not something we can fix on this.
On page 60, so this is going to be in the 1430.03, it's under item B, use, and then it's 2 subset D. I just want to, for context, so this says, for the maternity or paternity of the employee's spouse, child, other close relative. I understand that the employee, the spouse, the child, or the member of the employee's own household. But what would other close relative be that would be separate and apart from those 3 scenarios? Employee, or 4 scenarios: employee, spouse, child, member of the employee's own household. Can you give me an example of another close relative that wouldn't fall into that we would warrant them having sick leave for?
Grandparent,
Grandparents,
Parents,
Okay.
parents,
parent,
this is, and it's for illness or death.
Okay.
right.
Well, that's one of the options. So sick leave shall be in increments of 5 minutes or full days and may be taken for the following reasons. So this is why you can take sick leave.
Right.
So if other close relative could be a parent that doesn't immediately live in the employee's own household. Okay. Then maybe we should just say parent.
Well, it could be a grandparent.
No.
It could be an auntie.
it could be someone that they took
Could be
care
a
of,
foster parent.
or
live
someone
with
that
it, all
raised them,
kinds of-
yeah.
Okay. All right, I want to make sure that we're good with all of those various scenarios, because if they're not in their own household.
Well, my 96-year-old grandmother's not in my household, but you could bet if something.
But this is, I'm sorry, this one specific, okay, let me back up again. If you read it again, this one specifically is for the maternity or paternity leave. So your 96-year-old grandmother's not going to have a maternity leave.
Oh, I see what you're saying. Well,
So
I
this
was
one is
looking at-
specific to maternity or paternity. And so if we're talking specifically paternity of an employee who is an other close relative and not immediately in that person's household, like I'm
Okay, so
Sister
your
or brother.
sister has preeclampsia
okay,
and doesn't live in your house,
okay,
and your sister has kids, and you're taking time off to help your sister.
perfect. I just needed a
Very good.
scenario to fit other close
Right,
relative
but
that
you're
would,
choosing to take your own sick time to help.
right.
Which does run out.
Okay, I'm fine with that. I needed to have a scenario that I'm like, what other scenario? Good, sister, I see it.
Matter of
Okay.
fact, we got one kind of like that, similar now, the one at SPAR that we talked about, was it Anthony or whatever? The grandmother that's traveling to Virginia, I think it's Virginia or somewhere.
Virginia.
It's Virginia,
Right.
so, yeah.
Okay,
And
I mean, it's hard, I would hate to box in a scenario that may not fit the perfect, what
Right.
we consider, our perfect little box. I would like to have faith in our employees that they would not, I mean, if it's sick leave, they're gonna
It's
take
theirs.
it anyways, you know what I mean? And they're allotted that. It's not like we're,
We're giving
so
them,
I
yeah.
say, let's give our employees the benefit of the doubt on this one, and
All right.
well then I wonder if we even need all of the categories. That's my question. If it's the employee or other close relative, do we need the child, the spouse, the employee's own household if we're literally saying the employee or other close relative?
I'm comfortable with it because it lists some options, and then it also includes other close relatives or member of the employee's own household. I mean, it's just, you know,
Okay.
that's my opinion.
I'm good.
Yeah, I think if we take it out, it would be too broad, and it kind of gives us some parameters. I mean, because you don't want to say my third cousin.
That was where I was going.
So if
Other
we
close
take it out-
relative is,
If we take it out, it goes too far.
okay.
Yeah. I think this gives us some parameters.
And Board, Mr. Whitmer has brought up a point that NEOLA's model policy in this indicates that sick leave shall be in increments of 30 minutes.
No,
Here-
it's for a half day or a full day.
I'm sorry, for half day or full day, I'm
And you have
sorry.
5 minutes here.
Half day or full day. Now here, this has, I know that we do permit sick leave within Skyward for, you know, a couple of hours, something like that, for a doctor's appointment, something like that. But his question is, does the board wish to have that subdivision down to 5-minute increments? Or is there some other increment that is, I mean, does this fit our district?
Well, I'm going to tell you why I'm comfortable with the 5 minutes, okay? So you're allotted amount of time for whatever, you know, reasons, and you're a teacher and you know you have these times, but say I only need to be gone for 45 minutes. So rather than being docked for a complete hour, personally, I'd rather have the 45 minutes so that way I can have more later on should I need it. So, I mean, again, that's just my opinion. I could see leaving it at 5 minutes rather than requiring a staff member to take a half a day or a full day for something that they may just need 30 minutes of or something.
I agree with that. My question is, how is it accrued? So it's accrued at 4 days, but when it goes in, at not knowing how this looks on your actual timesheet, does it show of the 4 days that you're getting 8 hours per day on that? Like, or how does it look for them to have been requesting that if they're asking it in minute increments?
I can answer that.
Thank you.
Well, Reverend Cummings gets my time sheets, and so if I take an hour and 30 minutes off for a doctor's appointment,
1.5.
I put an hour and 30 minutes,
1.5.
and it goes for approval, and he clicks a box to approve that hour and 30 minutes.
Okay.
And saying that, I can also envision a scenario in which someone may have a series of doctor's appointments or something like that in which they need to leave 15 minutes early every day for
Correct.
3 days this week. So I can,
that would
Okay,
be
as
an
long as our system does it.
I
that's-
like the increments. I don't like 5. I'll tell you what, I don't like 5. I like 15 because it's a lot cleaner as far as for the hour, meaning I know it's going to be either 0.25, 0.5, 0.75, and it's kind of easier for accountability purposes, especially with staff if they're trying to figure out, well, what is, I was 5 minutes late, how do I do that on my timesheet versus if it was 0.25.
Well, if we're more comfortable with 15, that's fine. I just wasn't comfortable with the half
Yeah.
day or full day.
Yeah, I'm comfortable with the half day too.
Yeah.
But I think the 15 minutes increments are a lot easier for people to track, and I think it may even be a lot easier for our staff to track. I don't know.
Well, I don't know. I think
I don't
it's
know.
on the computer. I think it's pretty,
Is it,
The computer does
The
it.
does the
computer
computer
does
does
it.
it? Oh, okay, well,
yeah, it's not like you go in there and have to have your secretary or whoever take your 5 minutes. You just go onto Skyward and you just pop in your time and then it automatically.
I kind of
Yeah.
still agree with 15, though. I hear what you're saying, that, I mean, would you ever ask for somebody for 5 minutes?
Well, it would depend. If I had a very strict principle that those 5 minutes mattered, that I had to leave before traffic or something, then those 5 minutes might matter because, I mean, everyone just has different scenarios. I mean, 15 minutes is fine, but, you know, if you had to leave, like he said, say you had to leave 5 minutes every day, you're looking at 25 minutes being docked from your pay, as opposed to if you had 15 minutes, it would be an hour and 15 minutes. See what I'm saying? So it would be another hour that you're getting docked. So, I mean,
Have we had any history of this being issued at 5 minutes? Because I almost feel like, staff has looked at it,
Right.
We're going down a bit of a rabbit hole here. Are we making a problem where there isn't one?
Right, and I don't know, I am not aware, as you know, in the employment law context regarding docking an employee's pay for being late in the private industry or private sector. There are also indications that forcing them to take a longer period of time than a shorter period of time may be violative, and it also may be something that impacts working conditions if it's a change, and we all know what that means, then it implicates union things. So there may well be that altering this is not wise, if there's not a clear reason to do so. So I don't have any further answer. I'm just, I can throw up scenarios that make it.
I'm fine with the 5.
Problem.
I just, me thinking it's easier if it was me, if I'm the employee, it's easier for me to track 0.25, 0.5 points. But if the system is doing it, like you're saying, Skyward is doing it, as long as they can keep track of it, I'm fine with that. Do we need to take a 5-minute recess?
Yes.
Okay. Let's recess for 5 minutes. You all right? You all right?
Can you speak?
You have a
Okay, we're back on for the continuation of a NEOLA policy review. Superintendent, you found a couple of things while we were on.
I did, thank you, Chair. So as to 1420.01, terminal pay, with the question regarding the hire date and why the change recommendation to years of service, that is to align with the statute language as per the credit for years of experience. So to provide that opportunity to capture all of the years of experience in the state.
And so we didn't make that particular edit. We left it as the per staff recommendation, so we'll maintain that.
And if I may as well, to the current conversation on the amount of time in the system I pulled up, it is in 5-minute increments, just for clarification and Skyward.
Thank you.
Okay.
Thank you.
All right.
Moving to our next section then, as to now sick leave, 14, I'm sorry, we just dealt with sick leave? Yes.
Yeah.
So now moving to personal
Personal
leave,
leave.
1430.04.
Page 70,
70.
70, yep.
It's page 70 in your book. And there you have the staff recommended edits. Any edits to this?
Towards the bottom, it looks like we have an item E that doesn't have any corresponding information with it. Can you scroll up?
That's a formatting, yeah, that's a
Formatting,
formatting
okay,
thing that will
perfect.
be cleaned up.
So what is the difference between political activity leave and leave for political campaigning? Oh, maybe it's been changed since
Yeah.
the one that's printed. Okay, I'm sorry. Okay, so what's printed in our book is different than what's on the screen. Okay, what's on the screen is then the accurate, because our book is not that.
Correct.
Okay, I'm fine with that if you guys are.
You good?
Yes,
Okay.
I'm good with
Everybody
this.
good?
Moving on to the two mirror policies, 3430.04. This is the same for instructional staff.
What page is that?
They're all
It's
identical.
page 72.
Got it.
I'm
And then
fine
on
with
page
this.
74, as to support staff. I do see that on page 75, that item C, leave for political campaigning or to hold political office may be granted per, and it indicates in this one, board policy 6.34. Item B, this is on policy 44344. We'll check on this one as well. Scan down to the bottom of this policy,
As long
next
as,
to last line.
It
yeah,
should
as
have a
long as
header.
those subsequent policies mirror what the first one is.
6.34.
It
Because
says, see, it says per school board policy 6.34.
Which is now
That's going to be
1232.
changing And so the new policy will need to be inserted.
Yeah, it's number 1232,
1232.
political activities.
Did we catch that on the last one?
It's
It's
correct on
corrected on the first
1430.
one.
Correct on
but not the
14,
second
okay.
two.
So as
catch.
to
34.
this one, we're now correct. And
No,
now
it needs to be
moving to
fixed on
4430.04.
Good
We need to make that same edit.
So is it 12.32 or 1232? Okay.
It's 1232,
1232.
four-digit number, right.
Is there another issue with this?
So those
It's a heading
6.34s
called
need to be
leave
12.
for domestic
Changed
violence.
to 1232.
A and B, and then it goes into political campaigning, so I think C needs the new heading for leave for political activity. I'm on page 74, 75. Oh, there, it's been fixed. Okay.
Alright, so this one is good.
And then as to 4430.04, that same one. Changing the policy number from 6.34 to
1232.
1232.
What was it on?
1232. Okay, unless there are any other suggested alterations to that one, so we'll move on to professional leave, 1430.08. And that is on page 76 of your handout. And as you can see, one of the alterations made says, it had previously said with prior approval. It's been added with prior superintendent or board approval.
I'm sorry, what's the number?
And this is 1430.08.
Fine with that one.
Okay. Any edits?
You good with that?
I'm good with that one.
Okay, then moving on to the mirror policies, the same thing. That's 30.08.
And the difference on this one is when we're talking instructional staff, then compensation for their professional leave is not provided by the school board except when approved by the superintendent. So that's the difference in this one compared to the previous one. So the superintendent still has the discretion to approve compensation depending on what the professional leave would be.
Especially in a high-needs area.
And we would need to put that in procedures, something in writing.
Sure.
As per what that would be.
That's right. Okay,
Yes.
I'm fine with that.
All right, and then as to 4430.08, which is on page 78 of your handout.
Yeah, I'm fine with that too.
Now, this one, both 3430.08 and 4430.08, that first paragraph that says with prior approval does not say superintendent or board. It just says with prior approval. So that's been kept the same way. I'll just point out that distinction in case you wish to talk about that.
Probably going in procedure again, because they're most likely going to have to get their immediate supervisor to start the approval process and then work its way up through the chain. But that's a procedure, I guess, right, Dr. Gullett? Okay,
And it does say that in the
Correct.
second paragraph
correct.
about the supervisor.
Right.
Okay. Any other concerns?
Nope.
All right, we'll move on to jury and witness duty leave. That's 1430.09 as to administrative personnel, and that is on page 79 of your notebook.
Yeah, these are, so, yeah,
This is where the wills and shalls and mays, I reviewed these as well, so.
right,
That's,
And the Wills had it,
right, yes.
but mostly.
right.
Yeah, these are good for me. They're good for you guys.
I'm good.
Okay, and that's the exact same for 3430.09 and 4430.09.
Yep.
So unless anyone has any suggested modifications, we can move on to 2260, non-discrimination and access to equal opportunity, equal educational opportunity. And that's
here we
on
go.
page 82.
This paragraph looks familiar.
And as you can see from the section entitled Legal, there's a whole lot of interactions with federal, state law, and federal and state law, as well as administrative code. So any alterations that we make to this, we would need to do, and we need to exercise quite a bit of caution and some discussion.
Isn't this the paragraph that we worked for hours on to,
Yes.
okay.
And you can double check that, since this has been resubmitted to you, to ensure that that language meets what you had previously intended.
It was all about inserting it in the places that we knew it needed to go.
Yes.
So that's what
And
you're
it has
saying
been
happened.
inserted here.
Okay.
Just, I want to make sure that each time we lay eyeballs on it, that we are able to
Right.
all know that we want it as is.
And, I'm sorry, with the one that we have, the policies that we've tabled that are 1362 and so forth, I just want to ensure that whatever changes they make there are not going to impact this policy either, because I'm not certain what they're going to be doing there. Because I know we tabled the anti-harassment because of Ms. Gary, and I'm not certain.
I'm gonna, if I may, I'll allow Ms. Brown to speak to that, because she worked with Ms. Gary on that particular point.
Perfect.
So, 2260 is brand new. NEOLA gave us a new updated version, so we district staff totally edited that. So this is new to you in this pull folder from what was previously looked at.
Okay.
The other policies, they are going to try to mirror 5517, which will be the 1362, 3362, and 4362. But to do that, we have to make sure that they actually mirror completely, because they're all different categories. Does that make sense?
Yes.
Okay.
A question on the except as authorized by law, that applies to the entire category, does it not, in the general statement?
I guess in general, you could always say, except as provided by law. But specifically, I believe that you may be referring to the one indicating with age discrimination.
I thought it was military, but
Was it military?
maybe it is. Oh, there is a comma. There is a comma.
Right, because there are, discrimination itself is not banned, if that makes sense. What is banned is unlawful discrimination. And so there are some instances in which discrimination is appropriate if it's authorized by law. And I'm not talking about racial discrimination or something. It'd be more along the lines of age discrimination. Someone has to be a certain age in order to acquire a certain license, or a mandatory retirement age for judicial officers, or some other factors like that, where law has specifically prescribed an exception which does permit under the law for there to be permit and usually require, in fact, for there to be a discrimination made on some basis that would otherwise be protected. Military leave is implicated as well in there. So Yes, that's intentional, and it's intended to be put where it is because it only affects certain classes and not others. Broadly, you make a good point that it truly, except as authorized by law, is really true in all instances.
Oh, right.
But specifically, the language that is used by many of the federal statutes and
It helps
codes.
with this one for clarity.
Yeah,
Okay,
yes, sir.
okay, 17 years old to go into military service.
Right.
Yeah, got it. Okay, I'm good with that.
And just as a point of note, Board, I am grateful that in our third parties definition that we are including visiting speakers and participants on opposing athletic teams, as we've heard some dialogue about that in the past. So I appreciate that language going into this policy. But I have no problem with it. I just wanted to make that point.
All right. Any other concerns or issues with 2260? Seeing none, moving into 2266, non-discrimination on the basis of sex in education programs and activities. And that is on page, sorry, I'll get there eventually. My fingers are dry and not picking up the pages, sorry.
91.
There we are. Again, here, the drafting note was removed as was appropriate on that first page on 91. And we made it clear that we were selecting certain options on page 92.
On the very first line in this policy, I believe that's not how we want to have that worded, if I'm not mistaken. This is on page 91, but we've been pretty specific to not say on the basis of sex with a parentheses that says including sexual orientation and gender identity. I understand Mr. Whitmer has told us that according to the way Title IX interpretation is, that does apparently mean both of those things, but I think that this
Right.
board has been purposeful to not say it that way.
Fine.
Yeah,
Yep.
sex and,
There's a parenthetical including sexual orientation or gender identity, which is separately defined.
Bottom of 91.
No, at the very, very first word.
Discriminate,
Introduction, the school board does not discriminate on the basis of sex.
Oh, yeah.
And in parentheses, we're classifying sex as sexual orientation or gender identity. And I don't believe this board has,
if I may say also that based on current case law, that the courts always determine what the current version of what is discrimination on the basis of sex is, and therefore, I think I would agree that leaving that out, the parenthetical, just cutting that out, does make it actually more applicable long-term, because discrimination on the basis of sex may include things today and may include additional things tomorrow based on legal interpretation by the federal courts. So there is a expression that to include one is to disinclude others. And if we are saying, if we're putting the parenthetical in, we may be disincluding others. So I would probably, I would concur unless Mr. Whitner has any
no,
particular.
I agree, that's fine, yeah.
We'll strike
that.
the
I'm
language
comfortable.
that is in parentheses, if everyone's okay with that, so that it will now read, the school board does not discriminate on the basis of sex,
Period.
period, actually,
comma.
Eventually.
Right.
and delete the parenthetical along with the comma
And put a period.
Right.
in
Or-
its education programs or activities, and is required by Title IX, et cetera.
All right.
Okay?
I'm good with that.
All right.
In this same vein, and not included in this policy necessarily, I don't know if this board wants to entertain the idea of considering how we also reference this same issue in our schools, from documentation, certificates, ceremonial things like diplomas, roll call, et cetera, in our schools that are currently having one-off decisions that they're making for particular students from time to time. I don't know if this board wants to entertain the thought of having conversation about how we need to potentially address that in policy. Because currently, we're leaving it up to individual administrator discretion, and I'm not certain that that aligns with what this board wants to do. But that's what I am interested to know if you're willing to have that, or interested in having that, not willing, but interested in having that conversation.
I am. I got into that pretty heavily up in Tallahassee with some current legislation, and the sort of disenfranchisement of a student by a name that was not a birth name, that would almost render the diploma worthless, ongoing, and I've had some conversation with the superintendent. I think this is a very real issue, and then it leaves us open to liability by an employee that changes it without the permission of the family. And so this is a very, very hot current issue.
We had a situation just this past school year where it was the parents that were very upset that the school, the high school, was not willing to change to what the parents said they wanted, because there was nothing on the school record that showed that any name change had happened. And it was nothing intentional, but all the programs had already been printed, and the parents were insisting that all the programs be reprinted. So I think it's a very slippery slope that we do need to discuss. You know, my position on this is that if it's worth it enough to the parents to have their student, and I'm not even gonna say child, because when you're in high school, a lot of times you're 18 or older, for them to be called by a name that's different than what their birth certificate is, or then the family side needs to make that change and make it a legal name change. That's my opinion. Because otherwise, in practice, you are making school staff very vulnerable at the last second to these, a lot of times, which appears to be somewhat capricious, name changes. And, okay, I want this name this week, maybe I'm gonna want another name next week, you know. That doesn't make any sense to me. We're here to educate, and we're here to use, and I know that there's a lot of legal stuff going on with this because we don't want to make it look like we're being insensitive, but to me, it's way more sensitive to support what a family firmly says they want, or a student that's 18 and capable of making that decision on their own firmly says they want, and taking that step of making it legal. Because in terms of getting into college, in terms of getting in the military, in terms of getting a job, in terms of
driver's license,
social security card,
a driver's license, all of those things. So in my mind, we're not making it harder, we're actually making it sensible, common sense.
I too, this came up a few weeks ago. I think we got an email about some legislation that's going to be that's playing around with it. As a school district and those who are custodians of records, I think any record that we are putting out has to be actual, factual records, and we shouldn't be put in a position where we're creating a fraudulent
We're creating an
identity.
alias is what we end up
Correct.
doing.
And I believe that for that to happen, which covers us probably legally, is that whatever name that is legal, we are going by that legal name, whether they've had a legal name change or whatever it is. If we stick to the legal name change, I think we're we're protected because that's the documentation that we have. I think once we start taking it upon ourselves haphazardly, putting something on there that we have no legal documentation to say that this is that person's real name, then we just created a false identity. So until we get the legal documentation, I think we just need to stick with that.
Sure.
Mr. Brown?
Yes, and specifically, that double switch around, Representative Harding is the sponsor of that bill, and I really had to work to get this, but there's a potential liability they're concerned about for the district as a setup where someone would make that change informally and then have the basis to put the district in a liability situation, along the lines of what you just said. So this is a very real issue, and they're struggling with it up there right now.
Right.
And I think it really did resonate with me because we were going both directions, and we were in a liable situation. And so we never want to get there. So what you just said, I'd like to see capsulized so that we are clean, and then we can operate with procedure through a superintendent. I like that
I think
idea.
when we unofficially use a name, and then if we do it for a long period of time, people start saying that this is my name because we just unofficially used it. And then at point, graduation time, there's an expectation that we'll be required to put that on their diploma when there's nothing legally. We've just been unofficially calling you that by that.
They may not be able
as a
to fly,
courtesy.
for example.
As a courtesy, and
There are just
it may
all
put us
sorts
in
of
it may put the
ramifications.
district in a bad light. So, Attorney, I guess we need to
Lot of
kind of,
ramifications.
I guess we need to get some direction on some of that
Kids'
stuff.
nicknames on their diploma.
That's right.
I'm sorry?
I'm sorry?
We don't put
Exactly.
kids' nicknames on their diploma.
No, we
Kids
don't.
go through all their school lives. Their real name is Alfred, but they're known as a different name.
But they're honoring the name that their parents gave them, and you get to hear everybody's middle name during graduation. I mean, that's just,
Maybe for
not
the
on the
only
diploma.
time ever.
right. And
I've
so,
got nothing against
understandably,
changing
the
name.
program and the diploma are essentially like ceremonial documents as opposed to being the transcript that is the official legal record. However, what I'm hearing from this board perhaps is that we want to also increase the language so that we're helping guide our administrators in how they can handle those ceremonial documents as well.
They don't get set up, yes.
And so I'm not sure where that fits in this. Perhaps it's on page 94 in the education program or activity part of this, but Attorney Powers.
For your convenience, we have
Thank
pulled
you.
up 8330, which is the policy that we have agreed on as to student records.
Okay,
And it says each school will maintain a permanent cumulative record for each student. And Mr. Ayers is currently the person who does that for us, which will contain the data as prescribed by Administrative Rule 6A-1.0955 and this policy. Cumulative record shall include the following types of data, and it includes those things as our permanent information. Now, that is sort of the central touchstone for student legal name, and for authenticated birth date, place of birth, race, ethnicity, and sex. So that's current and as we have it now. Now, I am definitely supportive of the board having further conversation regarding this if they so choose, specifically because if we are doing things differently, we have a tendency, because it is our goal, to make accommodations where accommodations are reasonable or necessary. However, in our zeal to do that, if we have one location, one school, one teacher, one classroom who is doing an accommodation in one way that is not being done consistently at another, then that is something where if it's not following a policy, an unwritten policy, in the statute, the current case law is fairly clear that an unwritten policy may still be a policy.
Correct.
Just because you haven't committed it to writing. The unwritten policy, if it is practiced, is a policy.
Correct.
And therefore, if there are 2 or 3 or 4 or a dozen different competing policies that are going on, that opens the district wide open to a claim that there is arbitrariness. And you used a term that is always used with arbitrary, Mr.
Capricious.
That's capricious, you know?
I've been reading about it.
Arbitrary and capricious, that is, those two terms go to each other, with each other all the time in law. So if we are doing things differently at one location than another on an issue that really is a fundamental issue like this, that is more dangerous than remaining silent.
Yes,
So-
that's the crux, right?
So,
So from a timing
I do
standpoint,
think I have looked into the fact that within Florida law, currently in order to get a driver's license, you can't go to the driver's license bureau and say, you know, my name is,
Show proof of birth.
my first name is Aloysius, but I really don't like going by that, so can you just put my middle name on? That's not the way they do things. And that's true of name and gender. They require a birth certificate alteration or change. So that's, there are other records as well under state law that require that. So having a central policy that is consistent and consistently enforced and used is a good thing. Now, what exactly we do to ensure that we're taking into account all of those necessaries that we need to is a conversation for us to have with, you know, future work session or here. I mean, that's fine, but it is something that definitely needs to be addressed. But currently, the way it stands is under 8330 student records. That's our sort of central touchstone information right there, and any deviation from that is something that we need to be aware of. It needs to be, as a board and as legal and the superintendent, we need to be aware if things are operating in any different way.
so again, this is subject, the student records is again the legal transcript of said student.
Correct.
And I believe what we're having discussion about is a step beyond this, because again, while we may consider a diploma a legal document, it's not. The transcript is what the legal document is. The diploma is the ceremonial record, the program for the graduation, and we kind of keep sticking with that kind of senior and high school concept, but I would liken it also to a kindergarten, you know, or a fifth grade, or if not, you know, fifth grade graduation, or there are multiple age ranges where these ceremonial kinds of transitions occur. So I believe this board is, at least from what I'm hearing, might want to entertain the thought of at least making that part of it a little cleaner apart from just this student record. I don't know if that fits in this policy that we are talking here on student records 8330. I don't know if it fits in policy 2266, which is non-discrimination on the basis of sex in education, or if it is one separate policy altogether that just simply says, and bear with me as I just shoot off the cuff here, that school district employees shall reference students by a variation of their legal name as well as the sex indicated on their birth certificate. I don't know if we want to have a completely separate policy or if it needs to fit in one of these others.
Well, as to this particular policy, this is as to student records. How the student may be addressed is kind of not the same. That wouldn't be a proper fit into this policy. That would be something that we would need to address in a separate policy. However, within student records, some things go into the student's cumulative file and student records, which may be documents which do not contain the student's birth name, and it's okay for them to flow in that direction. And see if you can bear with me here. Information flowing into the student record from us, from the classroom, is fine. Flowing out, it may be a little different. and I'm thinking of the example of a ceremonial document for a fifth grade, you mentioned a fifth grade graduation. So if Maximilian graduates fifth grade and they put Max on that document may be part of a folder that becomes part of a permanent record. However, the fact that it was referenced in that way does not now mean that that gives an alternative. Now it's one of the pieces of information that's in there because he was called Max at some point, that it's going to be sent to as on a college transcript. The central point of information, which is relevant, is instead going to be the student's full legal name under Category A records of permanent information. So that's just one example that we would need to make sure that we understand.
I like that, and if that fits what you were saying, Chair, that was the crux of what you were saying, right? Am I interpreting it correctly? Yeah, so if we can get there, from my point of view, clean, I think we're safer. I think the student is safer, because we are not in the business of moving these variables around. We're in the business of recording a legal name, and that's a birth certificate, I would say. And so if that fits what you're saying, then I'm very comfortable with that. That's my objective. I just don't know exactly how to get there, and I like what I heard, and I like what I heard, so I'm good with that, if we can get there.
And that would be a good answer to the solution of what documents we generate to send out of that file being a document that is a transcript or a diploma, or where we pull the students, the sheets that are given to the substitute teacher of the class roll, or any of those factors. Those would come from the student's full legal name. And I'm very sorry if Aloysius doesn't like to be called Aloysius, but he may accidentally have a teacher who doesn't know him refer to him by the name on the student roll. Now, I believe actually we do have some categories within which things of that nature, like the student roll sheet or roster sheet, may already have taken into account what the student's preferred name is.
Something on a helmet or on a jersey, or something, and something some which way.
And
Okay.
however, that if it is, of critical importance to Aloysius that he not be called Aloysius, that on documents that we may be sending to his college or something like that, then that's something that will need to result in a Category A record being altered by the state on a birth record.
Okay, I'm good with that.
So-
Now, when it
so-
comes to how students are addressed or any of those issues, that's a separate policy that we don't have a policy for at the moment, regarding what our choices may be. So, and again, as I've stated previously, not having a policy can still be a policy if there are multiple ways in which it is being handled. So that's something for the board to consider how we wish to do that. And I don't have all the answers. I can just try to advise you as we go.
Yeah, Chair, if I may, just an example in my time was when we brought brought Alaska and Hawaii in to the Union. It was critical for records, birth records and all, for what became President Obama, that those documents actually, he was born in the United States, and it was a date. And it was very critically important. These things were speaking to, and then newspaper clippings and all sorts of things, because it went back, to 59. And so it was, it's critical that these things, the going back to look it's critical, I believe, in the final analysis.
So I think where we are landing on this is that we do not have a core or suggested or model policy which takes into account some of the wide and expanding edges of what we're talking about here. However, for some of the core policy stuff, we're on track with what we need to have as to student records in 8330 and the non-discrimination policies. Now, the gulf between them then is going to be some of those other issues which would require, in order for, if we're going to create a policy on that, that would have to be something that we perhaps garner model language from a number of sources and as just templates for us to use. But also, I do know that this is a constantly evolving field. And so it's one of those things, like in physics, as soon as you measure something, you've changed it. As soon as we create a policy, it is likely not going to be exact. If it's wide enough to be inclusive of what the current field of case law is, it's going to have to be modified and updated relatively frequently until that entire, until and unless that entire field of litigation settles down.
And then,
Ms. Thor, hold on.
oh, I'm
Ms.
sorry.
Thor, then Chair, Vice Chair.
I keep circling back around to, you know, we're tasked with preparing kids to be successful in the real world. And right now in the real world, you have a legal name that enables you to do certain things, very important adult-like things, get a driver's license, get a job, social security card, all of those things. So unless and until that changes, it's way too muddy right now in my mind to try to come up with a policy. And I think about procedurally, Dr. Gullett, who is going to monitor and enforce that every single one of our schools, every single one of our teachers, every single one of our principals is calling each and every child by the name on their birth certificate?
No,
I just don't see that happening.
no. No.
So I'm fine with keeping it simple, using what we have right now,
Yes.
because that makes sense in translation to the real world. And then the rest of it, you'll keep us updated.
Set it in
I shall.
concrete, let somebody else change it if they have the authority, but we're not liable. We're clean.
Vice
Are we?
Chair,
So-
Vice Chair,
So,
As pure as the driven snow.
Vice Chair.
so again, the question herein lies, do we believe that policy 8330 solves what we've discussed today? Do we believe that the interpretation of policy 8330 will translate on beyond the transcript into graduation diplomas and/or programs for graduation?
As long as it populates from skyward for our poor staff to
I
create the
understand.
diplomas.
I just want to make sure that, because from what I'm gathering, we're all on this, well, at least we haven't heard from Ms. King, but for most part, we are on the same page, that we believe that those documents, whereas they are not considered legal documents, but they are ceremonial documents of this district as well, that we believe they should also align with the
Yes.
legal name of the student.
Yes.
And if we believe that this policy says that, and that our employees should be interpreting as such, I just want to make sure that we're all on the same page there, because is this not a policy we currently have, or a variation of this? Maybe it's not. But we know what's been happening. And so if this is a current policy, or we have some variation that says something similar to this already in our policies, yet we do have these one-off decisions being made, then clearly it isn't clear. And so that's, and I don't know that, Terry, is this a mirror policy? Do we have some of this language already in our current policies? Or is this a new addition that we'll be adding into, from NEOLA?
I'd like to hear from the attorney if we can.
Yeah,
on-
give
on
me
your
just
question.
a moment.
If we're
Yeah,
clean, we're clean.
this is a NEOLA policy currently on point. We have a policy on student records, which does identify that where initial registration information shall include and those. So although this goes into other areas, including what information we can't keep and court requests of records, I will say this has been reviewed by Mr. Ayers as meeting what our current policy is and exceeding. Now, as to those issues that you're discussing now, graduation, ceremonial documents, it's a diploma, for example. It's not an official record in the sense that a birth certificate is, or a enrollment information being sent to another school, because the only time you see the information on the actual diploma is in the actual printed certificate that you get, or just like the graduation program. So those items, yes, if they're populated from skyward, and we insist that that is the direction that we're going to maintain, that if you wish your information changed, that it stay related to the exact information on there, I think we're within our right to do it. Now, there is case law currently which also says that that ignoring a student's need, if the student has a documented clinically or psychological need to be included and addressed by a particular name, those are factors that I don't have the answers to, except for the fact that that anyone could say that as part of their student's gender transition, for example, that student needs to be addressed by certain pronouns, which is completely outside of this policy or any policy that we have, and or by a certain specific name. And if that is the case, one of the cases that was most current that I believe that I may have distributed to the board was one in which the initial registration information was not allowed to be altered without a birth certificate, but then someone moving into the district could use whatever information that they had from the previous district, which might have been allowing more or less. So it's a long way of saying that I think that we're safe to base our diploma document on whatever we choose to. However, we are not, I can't forward the opinion that we are always safe from litigation regarding,
Either way.
yeah, in either direction regarding how a student may indicate that it is a harm to their mental health to be addressed by a name that they do not prefer to be addressed by, whether it's in a graduation document or something else. But then again, I think that currently there is, the DHSMV requires certain documents in order for them to put them on the card that you carry with you. And within Florida, that's the law of the land. So as to us, I think that whatever we do, we need to be consistent with. And I'm very sorry to give something that sounds like a non-answer, but the best that I can do at this point would be to say that if we are using some sort of consistent policy, it's far better than doing it sometimes and not doing it in others.
Chair?
Yes, sir.
Yes, so we do not live in an unresolved, infinite possibilities. And I'm certainly not governed by the possibility of an occurrence. I am governed, however, by consistency and what is considered appropriate at this time. And rock solid legal name, they can go change it somewhere if they want to change it, and then we may or may not accept it. You know, if they go to the Boy Scout troop and change their name and come back with a certificate, it probably wouldn't fly. But if they actually went through the proper procedures, then it would fly, perhaps. So I like rock solid. Infinite possibilities don't sway me in any regard. So.
And as to Reverend Cummings' point that there's some concern that by creating other documents and other names that are preferred names, we may actually be creating an identity that is not it's not a recognized identity. It's a non-entity, and
at
that
some point, we could be
can
in danger
assist with
Yes.
of, against a parental bill of rights as well, I mean, at
Yes.
some point.
Yes.
And I also, even within this context, the student, we have to realize, because these are also things which are become subject to court cases and that then explain things to us. And I don't mean those in the sense of, gee, we need to be running scared of court cases. No, we need to be doing the right thing as a board. However, we have instances in which the student's choice may be in opposition to the choice of the parents.
Correct.
And you may have, in Florida, we don't truly have child custody, we have shared parenting. And so you may have one parent who
Correct.
believes and agrees with the student, and the other parent does not, as far as some of these issues and what they're to be called. So, thrown in a bunch of additional factors into the mix. Now, I do think that that to the degree that we can show that we are being consistent, we get more points from being consistent than we do from taking into account every possibility of a variation. So we can chase variations around and say we need to try to make sure that we've accommodated for this, or we've accounted for this particular possible scenario, but ultimately it's likely to end up causing us more grief than maintaining a consistent ground. So
So the current rule is now that when parents register their kid, I've been at schools where these IPCs were dealing with it. When they register their kid to come to school, they have to provide a birth certificate, other documentation, whatever. And that's what the kid, is that not it, Ms. King?
Not always.
Really?
For example, what do you think, like, if we have children from other countries coming in
Right.
without a legal birth certificate? There's no proof. So that's why,
Right.
I mean, so there are scenarios, and I think, as you were saying earlier, it's hard to address
Right.
all
every
the different
scenario.
scenarios. So, but my thoughts are, because I've just been listening to the board, because I think about a year ago, I did say something by not making a decision, we're making a decision, and maybe you guys have found out that you've made some decisions that maybe you weren't necessarily aware of, but there wasn't a decision, so there have been decisions made on the board's behalf. My thoughts are, when the parent enrolls the student with the birth certificate or whatever,
Whatever
then
document.
that's their name and to the end, because I just feel like we're gonna be chasing anything and everything. That's just my thoughts on
And-
it. So
and
it's
I
clear,
concur.
it's concise, a decision is made,
And that's where I'm at. I don't want us to be like the cat chasing its tail
Yeah.
correct.
for 12, 13 years trying to figure out what name we're going to, whatever the parent puts on there as they're registering it, whether it comes from a birth certificate or document, alien registration, whatever it is that they come from, immigration papers, that name, until there's another legal name change, I think we're bound to stick to that.
Correct.
That's why I
There
think.
is a process, there is some discussion currently about the fact that, to the degree that anyone may argue that they, insist upon being called by an alternate name, so long as we provide them with the ability to alter our documentation within the school, by providing us with that updated document, that's fine. Now, there was a case in which the schools said, sorry, whatever your initial registration information was, that's what we're sticking with. Well, of course, if the information is updated and there is a new birth certificate, then we must.
Sure. And I think
I
we
can't
would.
envision a time when we
Adoption,
wouldn't
something,
do
right.
that.
Yeah, that's-
Or an
that's-
adoption, or
Yeah.
whatever the case may be.
That happens all the time.
So but I think it also, there's some discussion about the fact that if someone wishes to argue that they have been harmed by being, by an alternate name being used, that they need to have also exhausted their remedies by having done the rather simple task of altering that name legally. I mean, literally, it's a form that you can pick up from the courthouse, fill in the information, you know, pay your $150 or whatever it is, or get an indigency form and then submit it. Get a signature from a
to be
judge
honest
and you're
with you,
done.
we're in a culture now, we're in a day and age where people are changing their names left and right. And it doesn't even have to be a name that you, it can be Prince did a symbol.
The unpronounceable
you know,
symbol, right?
Some symbol. So, I mean, I think we just need to make sure that we're putting ourselves that we're in the right position to be legal all the way through without
that's a
infringing
moving
anyone's
target.
rights.
Yeah.
So we just have to do what
Chair?
we-
Oh, I'm sorry.
Yes.
I'm sorry, I wasn't recognized. As far as the legal thing, it sounds like it's very much a moving target.
Right.
And so in this situation, I feel like I've just heard it said 5 different ways, but I think we all agree that we just need to try to keep it as clean and simple as possible.
Right.
And that's the name that you have, and that's what's on Skyward, and that's what's gonna populate. And when you have 43,000 students, you know, if someone wants to be called Mosquito today, you know, maybe your friends will do it, but for academic and school purposes, it's just gotta be what it's gonna be. And I'm thinking about, like, schools that have their recognition ceremonies, and you get your Busy Bee Award and things like that. Maybe a school, the kid's name is Frank, and everybody knows him as Freddie, and that goes on there. So I don't know. Dr. Gullett,
I don't think that's what we're talking about.
I don't think that's what we're talking about either,
No.
but that's what it could
We
go
are.
to.
Yeah.
So we do have to have some clarity, because the schools, what is acceptable at one school and almost typical is not going to be the same at another school. And I was definitely reminded of that this morning at schools that I visited compared to other schools I go to. Each one has its own culture and vibe, so to speak. So that's a lot to broker with linear thinking. But at the same time, we do, I believe, starting with where it begins, which is how is this student registered? Because that kind of drives everything. And from there,
I agree.
Chair?
Superintendent.
Thank you, Chair. I'm looking at 8330 and thinking about conversations that you've had, and I do think clarity is going to be important, because we're looking at the permanent records, we're looking at directory information, but we're also looking at the implications of documents that are provided to students. So I don't know, are we saying that 8330 doesn't change?
No,
And
8330 is, I mean, we've discussed that, and that was, or it's been submitted to us for review, and this is the way.
Correct.
It's not one that's up for revision unless you choose to revise it. I mean, it's not one that is on our agenda to revise today. I brought it up for your viewing in reference to the policies that we were, you know, last discussing here. Specifically, in response to Ms. Campbell's question, and I think this all came back to the whole, to some of our anti-harassment and non-discrimination on the basis of sex issues.
Hold on, Mr. Burns.
Yeah, okay. So to my way of thinking, I've heard it now from 1, 2, 3, 4, 5, 6, you know, all the same. And it's what I would call like the Ellis Island name, you know, to your point, when people come in, or to the chair's point, when people come into the country, that kind of, however you come into, like in Alaska, they have a saying of, well, never mind, but however you come into this country, you get a documentation. It's a full legal name. So I don't think we should recreate that or put more blossoms on the bush, if you will. Let's just go with it as clean as possible. And if that works for you as our legal scholar, full legal name. If that works, certainly works for me, and I would not like to see it get wiggled around.
And I think that, if I may, just as this applies to our using it for, school purposes, sending it to colleges or whatever other access that people may have to be granted for our directory information or our permanent information, is fine. I wanted to address, Ms. Thrower brought up, the point of people, who's going to monitor who's calling everyone by what name. I don't think that my intention was to indicate that we needed to have it something like that. I think what I was indicating instead was that within our own peer groups, people frequently refer to us more commonly by a close or affectionate appellation or name, something that is more, they may refer to you by your first name, or they may refer to you by, a nickname or something else. But the farther you get away from your core group of your core social group and peer group, the more it becomes a formal name that you're referred to by. And so I don't think that anything that I was implying, current case law or anything, would in any way say that someone in the district must refer to a student by the exact name listed on the birth certificate. In the case of, the Maximilian versus Max sort of scenario, or some variation of their name, or even if they you choose to use a middle name or something else. It's more a matter of when we're generating records for that student, or when we are sending records for that student, having these, or generating diplomas or anything else. That's.
So, we've talked around this. I think that we all agree we have no changes to the student record policy. I believe that we're all on the same page on that. My question, and perhaps this is a question to Dr. Gullett specifically, do you feel that this covers what we're trying to accomplish? Because I personally do not. If in fact this board is wanting to say a diploma, that we intend this information, that it's a student's full legal name, this policy does not cover that. Because a diploma is not the legal record. A diploma is not the transcript that will follow that student. Nor is a 5th grade graduation certificate or an award that they might receive for field day. None of that is covered in this student record policy. So if this board is interested in entertaining the idea of ensuring that our staff has a little more clarity in the direction that potentially this board is interested in giving them that guidance, then I believe it's going to require an additional policy, perhaps mirroring very similar to what this says, but it's going to require something beyond this. Because right now, not having a policy is potentially a policy, and we don't have procedures in place written because we don't have a policy that says what we're talking about. So the only way we can have procedures is if we have a policy, and we don't have a policy that extends beyond the transcript, which is the legal record. So that's, I know we've talked ad nauseum about this, but that's originally the question that I had asked. And I appreciate seeing the student record policy again. I think we have no changes to that. That's absolutely accurate. But if what I'm hearing from the rest of us is, yeah, we want the diploma also to be the student's legal name, then we need to create a new policy that says that, because this policy does not cover that.
May I suggest then that in fact you do have a proposed edit to this policy, which would be certainly within the purview of this board, and that would be if it's specifically to address the issue of diplomas and/or student awards, or whatever block of information you want to say, that we add it to this policy, indicating that will be. I mean, I'd have to find the correct place to put it within this policy.
I like that.
Because this policy is more on the keeping of student records, not necessarily, I'd have to find where it speaks to the distribution of student records, what we send to a college, or what we send to, and that would be probably something that before I inserted it with a blunt axe, I would probably wish to ask Mr. Ayers where within such policy he would want to see that placed. So, but we can add, I mean, if the simple fix, if that's where the direction we want to go, is to add something to an existing policy, not necessarily have to create procedures. We could do it that way, but if it's firm enough that we wish it to be our policy that diplomas, period, or diplomas and/or awards issued by the district or whatever, shall be
Consistent.
shall be consistent with the student's legal
Permanent
name
record.
as
Yes,
defined.
perfect.
As
I can go
defined
with
by this policy, then that's a one sentence
Yes.
line to be added within this policy.
Perfect, well done.
So that would just.
I mean, it's probably going to need a separate heading as opposed to just maintenance of student records. But I want to ensure that that's the direction that all 5 of us are moving forward in.
I'm
I hear that seems to be what we're trying to get at, but the way this policy is currently written does not give that direction to Dr. Gullett's staff.
And it says that, the first line, in order to provide appropriate educational services and programming, the school board must collect, retain, and use information about individual students. And so, when we're talking about the use of that information, one of the uses would be diplomas and/or district awards.
Yes.
So the question then I would have, do we wish to limit it to diplomas? Do we wish to say district awards? Because then you got, what if FFA or Key Club or somebody, I don't know,
Right.
somebody
I
else
just
has.
think, personally, I just think diplomas. I mean, if we're gonna, like you, Ms.
That
Miller
has
mentioned-
value.
Yeah, that does. I mean, I could just see a teacher issuing an award and, you know, the kid is nicknamed Chip or whatever, and then they're getting reprimanded or something crazy. The district concerns me, but most certainly the diploma.
So I would suggest,
There's a lot, yeah.
there we go. Give me just one moment, I'm sorry. Okay.
Ms.
We're going to
King,
pull up, if
yeah.
we may, take a moment more of your time here to go to, we're going to pull up 5460 graduation requirements.
Would that be specific just to high school?
That's good. Yes, but then diplomas would be too.
I think of it that way, but, you know, we have pre-K graduation.
Well, and but that's, again, that's more along the
That's how
lines
you
of
get down
an
to-
award, like a,
Those aren't
That's like
graduation.
district.
right, that,
Certificates?
I mean, personally, I would like to see it expanded beyond the diploma.
Yes.
I believe that the more direction we're able to give staff, top to bottom, age 3, 4, on up to 20, 22, excuse me.
You find
The more direction we're able to offer them, the cleaner it is, and it helps them across the board. We all know that we received, you know, I go by my first name, but I know that my cousins go by their middle name, and they may have had, my cousin Ryan may have had Jared on his whatever award because it was something generated from whatever. Granted, it is still his legal name if it's his middle name. So if it somehow says a variation of your legal name, I mean, we've all heard it our entire lives. We knew the friends that went by their middle name. We knew the friends that went by we knew the friend's name William that went by Billy. We knew that. So it just makes it, that's my opinion, certainly I'm one of 5 here, but I believe the cleaner we can make this for our staff, the better, that they'll have the cleanest way to interpret what this board intends. But again, I'm one of 5.
sentence that I've just drafted that, and I still have to find where to put it, but tell me if this meets with approval. Diplomas, certificates, or awards issued by the school or district shall use the student's legal name or a derivation thereof.
Works for
What
me.
is derivation there?
Or variation, maybe?
Thomas, Tommy. So if they get an award from FFA
Like a derivative.
to Tommy, it's a derivative of Thomas.
Does that work with like
Don-
John Kennedy and he went by Jack, you know, quite
Yeah,
often?
Donald.
Does
Don.
that work?
if I issue you something that says Don Browning as opposed to Donald Browning,
It works.
because everybody, I mean, that's a derivation thereof. Now, we can eliminate the derivation thereof if you want, but then what that's going to mean is that you're going to have a problem if someone issues a certificate or award from a school that says Tommy instead of Thomas or Don instead of Donald.
Okay.
So,
Okay, if you all are comfortable with that, that's a distinction, sort of, I get it. Because it's incumbent on the person that's questioning it to have to
Yes.
say that it didn't derive from that. So that's good enough for me. I can go down that road.
I'm comfortable with
Something,
adding a
yeah.
sentence like that
Yeah.
to an existing
I like
policy
that.
that we're
Okay.
discussing.
Yeah.
and so now I would just need to find where I'm going to put that, so.
Are we all in agreement on that? I just-
Now, as to graduation requirements, we can insert this in multiple places. This same language, just as other policies have language that is repeated in other policies. So here, under graduation requirements, it says, it currently says it will be the policy of the school board to acknowledge each student's successful completion of the instructional program appropriate to the achievement of district goals and objectives, as well as personal proficiency, by the awarding of a diploma at a fitting graduation ceremony. Now here, we could say diplomas issued by the school board or district shall use the student's legal name or derivation thereof. Do we wish to, A, expand that to include diplomas, certificates, awards in this context, or leave it at diplomas since this is about graduation requirements? And secondly, do we wish to maintain the or derivation thereof, or just say shall use the student's legal name?
I would say we definitely need a separate category for the certificates and awards.
I believe you're correct.
Because those often are awarded at graduations, you know. I can't remember if valedictorian has a separate, but you see my point.
Now here, for example, this also then goes into scholar designations, merit designations, and
Yeah.
things like that. So perhaps,
You can put it at the beginning of it.
I don't see a problem with putting diplomas, certificates, and awards in this. If it doesn't apply, it doesn't apply, but if it does, it does.
I like that.
So,
That's fine, as long as this same statement carries over into other policies, so it isn't just subject to high school senior graduation.
Okay, yep, and so this would address the issue of diplomas and awards, diplomas, certificates that are issued in conjunction with graduation. And so now the question would be, where do we put the information regarding certificates and awards issued by the district for other than graduation?
Stick with it.
Whatever.
And would,
Oh, I was just gonna say, when a student comes to register, whatever policy that goes with, that might be a Stephen Ayers question, and when somebody brings in a student to register them, that would be part of the policy.
let me ask the board if I would have your authorization then to find out which policy
Yes,
this is appropriate to fit into.
yes,
Have a discussion with
Yes.
Mr. Ayers regarding that. Place the language that you agreed to, that is diplomas, certificates, or awards issued by the school or district shall use the student's legal name or a derivation thereof, and place it into the appropriate policies so that I don't have to come back to you for edits again and review
Yes.
it again.
yes.
Allison, you're good?
Yes.
I'm good. I'm good.
Ms. King, Ms. Story, y'all
Ms.
good?
King?
Well, I already made my statement. I'm firm on the diploma. I just don't want to see a kindergarten teacher issuing an award at the end of the year and call a student by their nickname or
Correct.
what the family use, and then we're like, oh, well, there's policy and whatever. I mean, I understand where you're going, but I'm like, are we just tightening so close that I could just see this, a scenario where it could go wrong that we may not intended, for it, if that makes any sense. But that's just how I think. So you guys can,
Well, and it doesn't, I mean, it would be in procedure if there was a disciplinary action that would be warranted based off of a violation of this policy, so that,
Well, it would
we're not
be.
touching that,
no,
so.
but if
Well,
it's policy and it's broken, what happens?
It's an infraction.
It's an infraction. You're
So
being
we're cuffing their hands.
correct. And
But
so
without
I'm like, is that really, as a board, is that what we want to do? We want to look at an award that may not have
That's an unintended consequence.
right, the unintended. But the diploma, something like that, I hold firm on that, I can see that. I'm not sure I see it to the classroom teacher that is giving away awards or whatever, and had called a student by their, whatever name that is, the entire year, and then they can't for that. I mean, I just, not sure that's where I want to hone in, if that makes sense, but that's just me.
Yeah, I see your point. I think that if we,
Can we get this to staff, superintendent, and let them look at it and give us a recommendation?
Having heard our discussion.
Yeah, because
Chair, if I
think
can
we
make one
kicking-
more comment.
Hold on, I think we're kicking
Yeah.
this too much,
Okay,
and we got a whole bunch of other stuff we
Yeah.
need to get to.
may I?
so do you,
It's important.
let me then ask, because I'm not, I won't go into doing what I was just gonna do if it's gonna be then, do we want input recommendations from staff and bring this back up and discuss it again? Or do we want the language that we talked about to be used and have me insert it? Because I don't want to come at it from two different angles and mash them up. And one thing that I might look to here is that this policy, I don't believe it's a true statement that anything that in policy isn't done right makes someone subject to discipline. We have enforcement mechanisms and enforcement provisions within certain policies that say a violation of this policy makes you subject to discipline up to and including termination, for example. However, policy also generally includes language of guidance that says, here's how we do it. Here's how we set these out. Now, then, if we notice that if that's not done correctly, then a corrective action doesn't need to be a disciplinary action either. It can just simply be, I mean, I'm sure we could have policy that says that, as to proofreading or any number of things that I can't think of something off the top of my head, but any number of things which say, here's the way that we shall do it. But if we were to create a document and it's not in keeping with that, then someone along the chain would say, hey, you can't do it that way, you've got to fix it. Now, only then if there were some kind of willful violation would that lead to something like insubordination, which has a specific enforcement mechanism which says that shall make you subject to discipline. So,
I don't know if I agree with that, because I could see maybe you don't get along well with your superior or whoever, and they're looking for things, and you give their wrong name on the award, and that could probably be used. So, I mean, that again, it could be. When if you had somebody really just looking in and they're like, well, you didn't do that. And then I'm like, well, if it doesn't mean anything, then why even do this? Because obviously there's not
Well,
any
it
teeth
means
to it
something.
either.
It means something, but it's not necessarily attached to a consequence or a punishment.
Mr. Brown?
Yes.
Wouldn't we just love to be able to say that in your school, if, Julie's always been known as Junebug, that you could put Junebug on the Bug of the Month award?
Right.
And not get chastised for it.
Right.
Yes, thank you.
Browning.
We're real close, and I'd like to make this distinction, and that is, one, that diploma, or all the way at the end, has huge potential dollar value, and I'm just using dollars, economic value. It's a big deal, especially if you went to the University of Central Missouri. Now, On the other end, and I'm sympathizing, but I want to bring you along if I can, and that is a birthday cake, what Ms. Thrower just said, you know, a spelling bee, little tag, you know, all those little things are insignificant, truly, in the long haul. And if somebody is on somebody's case, they're on somebody's case, and this won't be the issue. So I think these insignificants don't matter, and the diploma, the real certificates, the real issues do, a birthday cake, a spelling bee, or whatever. And I think you're comfortable with that. At least I'm comfortable with what you're saying, and I've digested it. I feel good about, and I think that takes us as a body to unanimous kind of thought.
I'm
if
just
it
going to
does.
disagree, so it doesn't
Oh,
take us to
okay,
consensus.
it doesn't.
I'm
Okay,
sorry,
good. Then-
I'm not
It's
going to be
not
in
unanimous
consensus.
Then go
consensus.
that
It's not a
way, yeah.
unanimous
Good.
consensus.
It's
I believe
disunanimous
that we are trying to,
consensus.
I'm sorry if I spoke out of turn. I believe that we are trying to give our staff, again, from K-3 to 22, direction and guidance on how we believe as a board that students should have their names on printed documentation of the school district. And if we only believe that they need to use a variation of their legal name on their diploma, then that is not what I agree with. And that's how I'll say that.
I'm with that. I'm with that.
I mean, so then
Can
that
you
means
say that
we
again?
add in
Can
the
you say that again? Because
Yeah.
I'm just saying that I believe we are trying to offer direction to our employees who care for those children ages 3 to 22.
Yes.
And that then we are then saying that the only written documentation of the school district where we actually care that they're using their student's legal name is on a diploma, then I disagree with that.
Oh, me too.
Because I believe that we need to ensure that our staff knows, if in fact it is the direction of this board, and this is one board member who feels this way, that any written documentation about that student, whether it's an award, a certificate, a scholarship, a diploma, whatever that might be, should include that student's legal name or a variation thereof. And
Yes.
if we only include that language in diplomas, then we have not given our staff, who does not cater to those students in senior high school and on up into Hillcrest and so forth, we have not given those staff members who cater to the majority of our student body direction on how to handle those cases. And that's, so
You just
I am
said it
gonna-
better than I did.
So I mean, I'm going to disagree
with
if
you.
we're only wanting to put it with diplomas, because I personally believe that we should ensure that all of our staff has direction for any legal any written documentation coming out of our district.
may I
I
suggest?
want to go back to, hold on, Ms. Power. I want to go back to where we were just at. I think we keep kicking this. I think we need to put it into the hands of our staff, let them bring us back something, and we look at it and move on.
I think we're there, Chair.
We're not there.
We're not there?
We're not at consensus.
I think from start to finish, we have to go with the legal name. That's what I'm hearing. But if it's not the case, then I agree, but that's what I'm hearing.
I have two things. 5451 is a policy on student recognition that I believe may be something the board needs to consider on this as well. Secondly, from hearing the concerns that you've expressed, and I certainly, I can certainly see Ms. King's point as well, that even though there may not be tied to an enforcement mechanism, it may cause confusion among staff of, or there could be a situation in which someone attempts to use it in a negative way, so here, this is the other potential resolution or potential fix. We talk about diplomas, certificates or awards. That's where we're having a little bit of a difficulty, because diplomas, we seem to all agree, but then also certificates or awards, on one, there's a issue of, well, the kindergarten classroom sort of scenario versus a more official document or something like that. There's also the possibility that we could, my language that I had suggested, of diplomas, certificates, or awards issued by the school or district shall use the student's legal name or a derivation thereof. I heard the concern that things that are coming out of our district. So if we eliminated school or district to simply say something issued by the district or by the, as opposed to district or school, are they the same? Does it make a difference if we say something that's issued by a classroom teacher? I mean, as far as are we wanting to limit?
Oh, I see what you're saying. So like a report card, might be.
But a report card is the transcript. So that's,
So like that, but then like, I just want to make sure that we don't have a teacher that's just for a silly award.
Yeah,
If that makes
the
sense.
unintended consequence would be that a de minimis or honorary sort of award that is just an achievement award then becomes a,
Reason for
it becomes problematic. But if what I'm hearing is that maybe that's what we want it to say, or maybe it's that we specifically don't want it to say that. So I don't think the board's in agreement on
It's
what you want
insignificant for me.
on that.
On the small one. On the insignificant little pin an apple on
But-
as a spelling bee.
but insignificant, does that mean that we are only classifying those high school graduates as those that require the significance? And that's the question, because again, if we only leave it at diploma, that is for one specific group of graduating seniors. And if that's what this board
No.
wants to do, then I'm in disagreement. I believe that student recognition would include certificates and awards and other things. written
I'm
in
saying
this board.
totally where you're coming from, and the insignificance is anybody complaining about a kindergarten teacher who did that. That's
Okay.
insignificant. I am saying you go from start to finish. That's it. The insignificance is some voice from the wilderness saying, that's not fair. It's gotta be you should be disciplined for using that name.
Again, I'm
So-
going to say it for the third time. Can we move on and let staff look at this?
All right, delete
I
that
think
then.
this is something they need to look at.
Yeah, because we're not going there.
And we're not there, and we got so many more policies that we could look at.
All right, for the record, 5451 is the student recognition policy that I would have dropped that language into. I'm going to cut that out, though. That would be the, that's the one that addresses, because you asked about one on diplomas, and then we had the student records policy. This is the one, 5451, as a student recognition. So when staff takes these to look at, they'll need to look at 5451, 5460, and then compare it with the student records 8330. And then, Board Chair Cummings, would you like to have us, would the board like to schedule this as a work session agenda item for us to address, or just as part of our NEOLA policy review for a future NEOLA, not necessarily the next round that we're doing? Or do we want to, there are three options as I see it. One is we can address it in March with our other March policies and have staff come up with these edits and address it then and get it in for those policies. We can not make any policy changes for now, get all of our NEOLA policies together, and this can be one of the future updates after these are all concluded. Or we can have a work session separate and unique to this one in which we address it.
So if we wait and don't address it sooner than when we approve the entire book of policies, then that leaves this particular 2022 class in a subjective state, correct?
He's in the same state that we were in last year.
Correct, okay.
So,
I like the March idea because I was thinking about upcoming, the school year is going to be over before we know it. And so I would like some direction in talking about taking it to staff. I would like to see actual schools be consulted about how expansive this really needs to be. It sounds to me like we're all in agreement about the diploma, the high school diploma. But the rest of it, I think that we still need to.
Yeah, because I'm just gonna add, I'm not sure, the more I think about that, this is the diploma, yeah, but the other stuff, I'm not sure is the hill I'm gonna to die on for, if that makes any sense. I understand, from the beginning, okay, you're always gonna use their name, and then there's no question. And I could also visualize if they did put their full name in parentheses, their nickname, or whatever, is this really, I'm not sure it's the hill I'm.
It's a big hammer.
Yeah, but I just want to make sure that it's,
Equitable.
Yeah, I'm comfortable right now with that.
Reasonable for the real world.
So let's bring it back in March. Can we bring it back
Yeah,
in
the
March?
sooner the better.
That's a
Okay.
full agenda.
Is that,
If
oh,
I
wait,
may,
wait,
Chair,
wait.
if-
That's right, March is a
As long as
huge
it doesn't
one.
get forgotten.
Hold on, Attorney. March is a huge,
It's already all day
March
agenda.
March
We have
is already extremely busy. I will
one
tell
work
you
session.
that we've got, what did I set for? our
bring it back to our next NEOLA.
Another work session?
If I may, yes. I think clarity on graduation 5460, it sounded like that was already addressed. And I do believe it needs to go to all schools. I think we need time to gather data from everyone and provide that data. Because I'm thinking of an example in my head of a second grade teacher who provides a perfect attendance award for the month of February. What does that look like? Right, just a practical example, but I think all schools would need to weigh in on this. We'd need to provide that data and allow time for that input to come in for the student recognition
I
piece.
say let's honor the superintendent's request, give them the time that they need, and bring
And
it
go
back
with the
to us.
diploma for now?
Yeah.
Because we've agreed on
Yeah,
that.
the diploma works.
We were in
We've agreed on
agreement.
the
Does
diploma.
that work for you?
I've agreed on diploma.
I've
I
agreed
believe
on
it needs to be expanded.
Okay.
Yeah.
For certain
5460
on the
is done.
diploma. And it,
So we are leaving the language that we just discussed, the diplomas issued by the school or district, diplomas issued by the school or district shall use the student's legal name or a derivation thereof.
I like that.
Yes.
Okay,
I can live with that.
all right.
And if I may,
That takes care
Chair,
of this year.
Yes, that takes care of that piece.
Superintendent.
Yes.
Superintendent.
Do we use derivations of a student's name on the diploma, or do we use the student's legal name, period?
personally, I think legal.
I think
just
legal
legal
too.
name.
I don't even like the
So get
derivatives.
rid of derivation thereof.
No.
So it would now say, under diplomas, diplomas issued by the district. Do we need to say district or board? Who issues diplomas?
District.
Okay. Diplomas issued by the district shall use the student's legal name. Do we need to say full legal name?
I'm not sure what they put. I think they do put their full name on there.
It's whatever populates from Skyward,
Yeah.
right?
Yeah.
What
Sometimes.
populates from
Should be.
Skyward? Is it full legal name?
should be.
Yeah, that's good. That's fine. I'm good.
It should be their full legal name, so
Yeah.
I think you're good if you put full legal name.
Diplomas issued by the district.
Because full is really redundant.
Well, Jeremy Powers is my legal name. Jeremy Tate Powers is my full legal name.
Okay. Then it isn't. So
Jeremy
go
T.
with-
Powers is not my full legal name.
Okay. Let's
So
go with
what-
the legal. I'm happy with legal. I want to get something for this year's students, diplomas.
And that's my question, because I don't know the answer to this. One of you may. Currently, is what goes on to the diploma, has it been whatever the first, middle, and last name presented on the birth certificate is?
I believe that to be the case.
That would be a Stephen Ayers question, wouldn't it, Dr.
To
Gullett?
confirm it, we would have to confirm that, yes.
And that just, and we can simply
So let's-
leave, we can ignore that issue and
Legal
simply
name.
say,
Attorney Powers, hold on, we need to recess. We want to recess,
sure.
and we're going to come back in 30 minutes, okay?
Okay.
We're back on. Continuation of our NEOLA policy review. I think we just finished, it's 2266.
Yes, sir. 2266, non-discrimination on the basis of sex in education programs and activities.
So we will push forward to 2340.
2340, field trips and other district-sponsored trips. And let me find the page number.
I believe it's 113.
113.
Ooh, moving right along.
Okay, this is policy 2340, field and other district-sponsored trips. There are some strike-throughs and then some additions that appear to comport with statutory language. And the additions are what we are, what staff was seeking for the board to approve and move forward with. And that's the underlining that begins with pursuant to state law.
Yep.
1, 2, 3 paragraphs ending with whistleblower protection.
So this green is coming straight from the statute? This additions?
Oh, I don't know that it's coming straight from statute. I think that it incorporates statutory language, but it's meant to comply. So unless anyone has any alterations to that, I will move to our next one.
Any issue, guys?
Good.
We're good.
I'm good. All right. Pressing forward.
Yes, that was pulled, so we won't be talking about it today.
Sorry?
Okay, 3124, the drug-free workplace, that was pulled by staff. It's not ready for review.
Not ready.
Okay.
So we're not going to address that one today.
Okay.
That is one, and I should probably take a moment right now just to say, there are a couple, should not be many, but there are a couple of cleanup items remaining. This would be one that we would need to bring back, and then I've been made aware of at least one other that has some edits for consistency's sake that need to come back and get board approval. If there are any others of that nature that we either A, don't get through today, which I think we will, but B, have any other emergency authorizations needed or anything to come back, then I'm requesting that staff get those to us by March 1st so that we can have those considered, reviewed, cleaned, ready to go for our policy section in which we'll be dealing with bylaws. And then we'll hopefully not have very many. There should be none other than odd duck situations like the drug-free workplace policy or the or one that I've just been noticed was possibly internally inconsistent with another policy we have. So if there are any others like that, though, we'll address those last couple at that time. Moving then into PO 5517, anti-harassment. We did discuss 5517 in the context of some of these other policies, because, Ms. Gary, yes?
This is the one.
Yes, it's the core that we're going to be inserting into.
Brand new policy.
Okay, so this is, on 5517, the anti-harassment policy here. This is a brand-new NEOLA policy
Do you need this?
that the board had asked for us to do the update of. And that, this update, I'm going to confirm with Mr. Whitmer, has, with the strike-throughs that we have there, that takes into account what this board has previously reviewed, discussed, and determined its statement and its specific alterations to the prior policy were. And that's 5517. So essentially, the newest, most updated anti-harassment policy, along with the changes the board has previously approved in each of those other policies that we had been referring to just as the dirty dozen, simply because there's 12 of them. I guess it's the 13th now. And so this would be the language that's inserted. And then this will be the basis, the core, which will then be inserted into those policies that we discussed earlier today that Ms. Gary is going to bring back. And that is, those were as to policies. One moment. 1362, 3362, and 4362. So the bones of those three policies will be this policy, and that keeps everything new and updated along with the board's changes. Okay? All right. Then moving into participation in extracurricular
5610.
activities, which is
5610.
561, sorry,
I'm sorry, 561005.
yep, 5610.05. Page 132, thank you, Ms. King.
Here. Move defined. And then it's down here, move defined. So
So is the blue NEOLA changes in this policy?
Is that the one where
it's local. No, this is local.
I'm sorry?
That's.
step?
That's staff, those are the
it's
staff
not-
edits?
It's not Neola, no. It's not.
Okay.
So the bottom of page 133, undue hardship appeal, which will require, it's number 5 under D5.
Okay, so that was a staff edit.
Authorized for good cause in the district.
Yes? Oh, okay.
Let's see. Transfer defined, move defined, exception. Student may not participate in a sport if the student participated in that same sport at another school during that school year unless the student meets one of the following criteria. And then, sorry.
Move defined is defined twice.
Okay, move defined is moved twice, so we've got a mistake in the staff reviewed one, so we've got to fix this now.
Where at?
D, under D1, move to a new residence. Move defined is defined. Now, it is also defined under
top.
the top. Move defined.
Right, yeah, it's up there and here.
So we've got it under move to new residence,
You got it
and then we
twice.
define move, and then move to under move to new residence, it's move defined again.
And then my question to this one would be, where is this, where it says Athletic Transfer Review Committee? Where is that listed prior to its first mention in here? That, who will comprise that committee?
Again, that's a staff edit. I don't know the answer to that.
I would think that that committee would need to be qualified, who that committee is. Am I making sense, guys?
I've never heard of an athletic transfer review
Me
committee.
neither.
Have we always had one?
So, we
I
can put,
would say then that this
we put a question
policy
mark by it, the
would need
staff can
to have,
clear it
would
up
need
for
to
us.
be further reviewed. I don't know the answers to what these questions are.
Okay,
And Chair, if I may,
Yes,
I have the original request, and I'm also hearing from Ms. Talbert. I mean, there have been edits on the document to address some of the move items and definitions on here. I think that probably didn't get amended from page 1 and page 2.
so
Uh,
So it might clear up some of that language. I see notes on here, formatting and notes for the definitions, as
right.
per your prior comment.
Yeah, because that Athletic Transfer Review Committee is mentioned on page 133 and letter G, 134. And I guess that's a definition we need to kind of have on who
CC here.
that is, so we can question mark that, I guess, and highlight it and send it back for edit or review.
He wants to know who this committee is right here.
So the question is, who is the Athletic Transfer Review Committee?
Since it's mentioned twice.
I'm putting that in as a note for review.
My notes indicate, Terry, that you'd said that NEOLA has to change this to remove some of this language. Updates on here are the notes that I have. So perhaps we does NEOLA have to intervene and do some updates for the transfer? Okay.
Okay, so,
Perfect policy to pull for update.
okay, so this was one that we'll bring back in March.
Thank you.
Make sure that gets brought back.
Yep.
Okay.
I'm writing it down.
5610.05, okay. 563, anything else on that one, aside from what we just discussed in staff review? Okay. 5630.01, seclusion and restraint of students with disabilities. This has been now vetted in keeping with, I spoke with our ESE department, and also this has been handled with, was it Ms. Oliver that was on this one? I'm sorry. At any rate, though, this has been reviewed based on the fact that although the title is Seclusion and Restraint of Students with Disabilities, if you see from the first line, it says, "It is the policy of the school board to prohibit, not limit, prohibit the use of seclusion and to limit the use of restraint in the education and discipline of students with disabilities to certain circumstances," and it's outlined there. Specifically, also, there were some edits as to the staff that were, the staff training and who it was that is authorized to utilize these and what training they have to have. So I've reviewed this. I didn't find anything that was out of the bounds of what it needed to be. And I believe that a lot of people have laid eyes on this to make sure that it's in keeping with what our current status of Florida law is, as well as what we desire out of board policy. So this is the right this policy unless there's a question that we want to address. I think this takes into account statutorily what we're required to do. As you can see from on a number of these pages, there's a lot of edits that keep in line with the most recent legal updates regarding seclusion, that it is struck from most of these considerations. That would be a clear message for staff that, it's not, that seclusion is not, just because seclusion's mentioned 100 times doesn't, it would almost give the impression that it is a valid option. So it's struck here where it does not apply, which now it doesn't apply in almost any situation.
That's state statute now.
Yes. Okay.
Okay.
Any other concerns to address on that one? Okay. Moving on into 6610, school internal funds. Dr. Gullett, would this be the one that we need to compare with another and bring back for the board?
Yes, thank
Okay.
you. Attorney Powers, it would be 1113.
So I'm going to bring it to Mr. Whitmer's attention now too, because I'm going to recruit his efforts a little bit in helping us with that.
Certainly.
It's been brought to our attention that on 6610, there may be some internal consistency problems between that policy or some edits within that policy, and the other one being 11.
13, and I can
11.
tell you specifically, it's the second paragraph
Okay.
on 1113.
And so Ms. Boston Ellis and I will work together on that. And if I have some questions for Mr. Whitmer, I'll just ask him to lay eyes on that so that we can bring it back and hopefully make it a quick approval for the board that fixes what our intent is. Because one of these, 1113, was previously looked at, 1113 was previously looked at and passed through, but it creates a conflict with this one, so. Okay. So you adding that to the list of ones that are bring back, so we got 3 at least, right? 5, okay, 5 total that should be brought back. And hopefully each of those we brought back with cleaned up enough that they don't take long. School food service program, 8,500. Staff has reviewed this as well. And that begins on page 148. Actually, 149 is where the text starts. As you can see, this is also a policy which has an awful lot of, it's very highly statutorily driven.
Right.
By both, because food service programs involve a lot of federal and state dollars, so, and federal and state legislation.
So it's just mirroring that, really, right?
Yeah.
Yes.
Okay.
So I do not see anything within this that would be something that would be grounds for us to alter, unless you see something that you wish to bring out to make any comment on and us to look at and see if there's a reason why something might have to be there or not.
We're on page 153, Mr. Browning.
Okay. Hearing none. Moving right along to 8510 Wellness. 8510 Wellness appears on page 153. And you can see the edits begin on page 154 there.
Some of this comes from the federal
Yes.
recommendations.
We got rid of the Spark curriculum.
Right. And I think that is something we addressed during our last
Yes,
session.
yes, yeah,
And therefore,
Updated.
this has been submitted with those updates for your review. concerns or discussion? Hearing none, we'll move into 8800, religious patriotic ceremonies and observances.
Oh, hold on. I just got a question.
Yes, sir.
So the time to eat dropped?
Yes, it used to say,
25 minutes.
I've passed that policy now, but it says, it said something like 25 minutes. Now it says something that is a little
20.
more specific, and it says so that students will have 20 minutes from the time of getting their lunch and getting out of lunch line, something like that. That way it's,
Students will be provided an adequate amount of time to consume their meal with a minimum 20 minutes after receiving their food from the line.
right. That way, if there was if the front end of the lunch break or period in which somebody may get in line, be waiting in line, and by the time they get out of line and manage to get to their seat and everything, they only had 15 minutes or 10 minutes or something like that. This really ensures the intent, which is kids have an adequate time to eat their food.
Yeah.
So basically, that's based on the last person in line.
Right, well, see what can happen, and if you think about, like, again, I'm gonna say elementary, because that's what I'm familiar with. Say there's a class, a couple of classes behind you because for whatever reason, teachers are late. But say you're there at 12 o'clock, but it takes your students 10, 15 minutes to get
To get through the
and then they
line.
come back and they're expected to pick them up in 10 minutes.
Right.
So this is good policy here, because it's ensuring that those
They get the
students get
time
at
set.
least 20 minutes to eat, rather than grab and go and, you
Right.
know.
But that's what I'm asking. Is the 20 minutes from the last kid that gets their tray, or how do
Well,
they
it
do it?
says after receiving their food,
So any kid?
so that's what this says. So
Okay.
after they have their food in
That's-
hand,
Any child, that's
Okay.
correct.
Every kid gets at least 20
Make
minutes?
sure that they have full 20 minutes to
Okay.
eat.
yes,
Not that they're present in the lunchroom, but that they have time,
Right.
20 minutes to eat.
Yes.
Correct.
That's what I'm asking.
yes.
Correct.
I'm
So
good
this
with
is
that.
good.
Yeah.
Yes.
Yeah, I'm good, because I've seen that what you said, that they've been sitting there.
Yes.
Thank you, sir. You leaving your jacket, Mr. Brown? That they be sitting there in the lunchroom, and, you know, you have a group that's already did theirs, and
Yeah,
now these kids are just getting their tray, and they're sitting down, it's like, it's time to go.
correct.
Yeah, so that makes sense to me.
That's correct.
So for the record, it's gonna be 3 of us. A quorum still does exist, so we can continue forward.
Yes, sir. Page 158, religious and patriotic ceremonies and observances. This section here does take into account current federal and state law, as well as some case law, which is not common, but is not common within our policy, but that's the point here is interpretation by a case law of what students need to need to have, and that is each of these paragraphs deal with things that are either required by federal statute, required by Florida statute, or required under current interpretations of federal case law. And the Gregoire versus Centennial School District is a federal case, and Lee versus Wiseman is a Supreme Court case. Just to provide context to that, the first paragraph gives a little bit of the explanation for the policy, which we usually don't put into a policy, but I think it brings additional clarification.
I mean, I guess this one's gonna be my baby. Shall. The language on that second page, shall not include. So are we violating our policy when we have a moment of silence in a board meeting?
I think we should be modeling it, because that's what kids are
But this
doing.
says shall not include.
Well, the moment of silence was just passed last year.
I think he's talking about the very top of the page. The board shall not include religious invocations, benedictions, or formal prayer at any school-sponsored event. Now, that's as a result of current case law, and which indicates that there are, and I can get into that more if you want, but the basics are that the school shall not include our religious invocations or formal prayer. There's an entire separate portion of that for what a student chooses to do. But that there are some limitations on exactly how we can go about with invocations or prayers at a graduation, for example.
What about a board meeting?
It says school,
Can we start with a prayer if we wanted to, or at least do the moment of silence?
we've had prayers.
I know we have, but
Yeah, that's why I'm asking.
I would want to be able to cite line and verse before I gave answers as to exactly how, and I can't do that at the moment, so I won't attempt to.
because I know the county commission does a prayer before their meeting, but
County Commission and City Council.
county commission.
And City Council.
Oh, and city council too?
Matter of fact, they bring their chaplain in from the police department at City Council.
Oh,
Do you have any input, Mr. Whitwell?
Well, I've been all over the state, and it varies a lot from district to district. Some districts have prayer, I'll tell you that, at their meetings. Many do not. This is your policy, you can change it. You can delete things if you don't like it. This is what NEOLA recommends, but
Oh, this is NEOLA recommended, okay.
Yes, this is a NEOLA
Because
policy.
I remember when the shootings happened at Marjorie's, schools around the county prayed. And then I remember when we had the shooting at Forest, we prayed.
I wasn't on the board then.
I think in a
Well, we were
public,
praying.
Huh?
I think in a
So I
public
wasn't on the board
meeting,
then,
I
but I was
wasn't
at
either,
the
but I
church and we
remember-
were praying.
Yeah. And I remember they were at school-sponsored activities. That's why I remember that. So I don't want us to kill ourselves or not kill ourselves, you know. We need to, it says shall not.
What's our current
And
policy?
shall not means that there's no,
Yeah,
am I, y'all reading, how am I reading it?
yeah, I say we remove that. I mean, it's my understanding that it's up to the district, correct? Or,
yes. It's a lot different when you're talking about a public meeting that's open to the public and people can come. You may get criticized, but it's not like a constitutional violation, which would be in school where students are required to be present. That's where I think you have to be careful with students.
And I can indicate that one of the reasons that Lee versus Wiseman is stated there as a case law cite to this, this is one of the most confusing issues within the entire school prayer debate, specifically with graduations, okay? But Lee versus Wiseman, 1992 Supreme Court case, indicated that inviting outside adults to lead prayers at a graduation ceremony is clearly unconstitutional. Lee versus Wiseman began when prayers were delivered by a clergy at a middle school's commencement exercises in Rhode Island. The school designed the program, provided for the invocation, selected the clergy, supplied guidelines for the prayer. Supreme Court held that that violated the First Amendment's prohibition against laws respecting establishment of religion. However, with student-initiated, student-led prayer at school-sponsored events. That is, although not completely clear, it is more clear in that it is possibly permissible in certain circumstances. 2000 Supreme Court case Santa Fe versus Doe involved traditional practice of student-led prayers over public address systems for a high school football game. And there's, depending upon a number of factors, which are not all outlined here, they may be permissible and they may not be based on current Supreme Court case law. So this is really something that is more of a, if I were going to do anything to this policy, I would probably, if it's intended to be descriptive and guiding for staff, add significantly to it, as opposed to removing or taking away, because what's left in here is probably, for example, that phrase, "The board shall not include religious invocations, benedictions, or formal prayer at any school-sponsored event." I'm not sure that's completely accurate, that they may not include it. For example, an invocation. However, it is relatively clear that in certain circumstances, a formal prayer being led by the school would be violative, but there are circumstances in which some invocations would not be. So
This also takes out, though, in the sentence above that, excuse me, this also takes out baccalaureate programs, because it says shall not conduct or sanction. And this district, every school does not do a baccalaureate, but there are baccalaureate programs, and I think the way it's written now is students are not, it's not mandatory for them to attend a baccalaureate programs. My baccalaureate was right here in this room, and it was mandatory that you participated. That language has changed, so now it's optional. So this here, the way it's written now, states that district-wide, you cannot have a baccalaureate program.
Well,
Well,
I just, oh, go ahead.
Go ahead.
Yeah, I read that a few times too, because it says you shall, or the board shall not conduct, and that didn't set well with me.
I would concur, and what I would ask in this policy, rather than putting this on staff, I will take it on myself, if the board would like for me to do so, to do the research required to make a clear and absolutely as descriptive of a policy as possible, using templates from districts that I believe are situated in such a vein that would address the issues that you guys are talking about right now, and cleared up so that the language is also sufficient to me in a legal sense to make it work. Because I don't want, as your board attorney,
Yes.
and I think as board members, I don't think that just as a matter of remaining safe, that you wish to put a blockade up against something which may be permissible.
Right.
And
This-
so,
'cause
Absolutely.
the
if
way
I'm
this
reading
looks-
that properly from
means
what
a lot.
comments you've said now,
Yeah.
what I would like to do is to not utilize this policy at this time.
Right.
Though the policy is, this is accurate, I can't find fault and say that it is not usable, but I believe that there's an old phrase, the devil's in the details, right? In this here, you could write a book or a treatise about exactly
Correct.
what this is. I'm not gonna do that. What I will do is I will try to provide a nice toolkit for staff in the form of a policy, which outlines and answers some of the questions that I believe this board has related to this particular issue. I will, once I have put that together, I'll bring it to the superintendent so she and I can look it over and see if she has any suggestions with me. And then I will bring that to the board and see if the board has any alterations or discussions it wishes to have regarding that. And perhaps also that might be a good time to publicly clarify that position that the board is making on this particular issue.
Yeah.
Is that what you'd like me to do, or is there any other guidance you'd like to give?
I want to hear from my colleagues, because it seems like, to me, it's like we're mandating no baccalaureates.
I don't want to artificially limit these things.
Yeah.
Unless, if there is something, I want to be clear that if there is something that can get a teacher or a school district in clear trouble because we absolutely are prohibited from doing something,
Right.
that we spell that out in policy, and that's fair. However, if there is something that is interpretive, or then for Pete's sake, let's make sure that we have the interpretation that is going to spell out what we can and can't do.
You guys?
Yes, I'm comfortable with all of that. I'm wondering on the specific issue of being able to do a prayer here, starting Tuesday or Thursday or whatever. Can we do that? That is pretty meaningful to me, and I think there's precedent certainly in our other governing bodies right here in Marion County. And I'd rather be able to start with that sooner than later. And is that something that would necessarily have to go in our policy?
No, but if this is a district-sponsored activity, it's probably something we can address within the policy. But I'll make sure to reach out where I need to find, and if the language is something that needs to be in policy, then I'll make sure that it's there and at least have the answers to those questions. There are attorneys that do only this for a living, and they probably don't do some of the other stuff that I do, but I would want to make sure that I have done my due diligence and homework on answering those kind of questions.
Just for interest's sake, Dr. Gullett, at your other, in your other counties, what have you seen around?
Thank you. I would say it's back to Attorney Whitmer's comments with regard to requirement of student attendance, right? If it's a student, if it's a requirement for attendance, we cannot provide that by law, allow that. But when it's optional, and I'm thinking of an example of a Fellowship of Christian Athletes, which is a student organization, right? Not required, permitted, and so allowable. So seeing where there's been, and by case law, I'm not the attorney, that's been permitted.
And that is a student sponsor.
That's true. However, when you deal with things like graduation events and things like that, there's also some interpretation that although your attendance is not required at a graduation ceremony, that also it is considered to be one of those life events, which is
Correct.
has such weight that
Correct.
that
Right.
we can't just run it however we want
Right.
to, just because it's optional.
Which
So-
is case law on that.
right.
Right, I
So-
think you mentioned that.
Yes. Yes.
Recent, like 2010, or,
Yeah.
yeah.
So if you want to give me an opportunity to clean it up as best I can, and then you can tell me whether I succeeded or not, and then you can, evaluate me on that.
Well, it was comforting to hear Mr. Whitmer, too, when you shared, sir, that, again, a school board meeting, it's a meeting of adults, it's open to the public, anybody can come and go as they please. I think it would be great. But that's just me.
No, absolutely, I agree too. I'm a prayer, even if I don't say it out loud, you can guarantee I'm praying, even
Exactly.
in my mind, even as I sit up here.
Right? I
And
think
as
it
per
sets a
that-
nice tone for the meeting.
As per that request, I'll actually look to get some language that would address that as well, and you can decide whether or not you want to put that language in to the policy, or whether we just remain silent on it. It's up to you.
So when can we start? Verbally, because I hear Ms. King, I do the same thing.
Oh, you mean when can we?
Yes.
Well, we've done it. I know we've
I
had
know we have,
pastor-
there's
We've
precedent.
had a pastor up here, and there's been
That's what I'm
times
saying, we
when
have an
times and
underutilized
Yeah.
man of God right here to my left.
Well, it is also true that a school district or a school employee may not prohibit anyone from doing what they wish to at any time either. So if you chose to pray right now, you are certainly welcome to do so. So I'll
Thank
do
you,
it.
Attorney Powers. God bless you.
I'll do what I can to try to put something into something that will mean more than the model policy that we have right now.
Yeah, I think
Yes.
that's good. I kind of look at this as trying to, I mean, we know like prayer or whatever's been taken out of our schools, and I feel like this is like the nail on the coffin, so to
Correct.
speak. Like, this is just finalizing it, and I'm not okay with that. So.
No, I'm not either, and it would be interesting. I haven't frequented a lot of city council or kind of commission meetings, but it'd be interesting to see how they do them. Sounds like you have familiarity with
Yes.
that, and I'm just thinking of all of, not pushing it on anybody, but we know that our community, there's a lot of opportunities to exercise your faith, and
Right.
that's important.
And I go back to several times when I was in school, several times where I know that as a school, we prayed together. I can remember in 6th grade when President Reagan got shot, we prayed. I can remember in the 11th grade when the Challenger blew up, we prayed. I can remember here locally, I was in school, but I remember when again, the Marjorie Stoneman Douglas situation in Forest, and they prayed. And so I just don't want us to penalize ourselves for doing something that we normally would do in times of trouble, especially in times of tragedy. I can remember when they had the World Trade Center situation, and my kids came home and told me that they prayed. So that was something I expected to happen. So, and I as a parent, I didn't get upset about that. I'm different, but I just don't want us to be. I don't want us to limit ourselves on what we can do and what we cannot do. And will every person that's ever come into our meeting be a Christian person? No, I understand that. I do understand we're a diverse community, but I just don't want to limit ourselves to certain things. So.
And too, it could be something that each board in the future would discuss at their organizational meeting, are we going to do a prayer? There may be a board member that maybe is of a different faith that wouldn't be comfortable, but I feel like those are the kinds of things that could be worked through, and in the end, we take our jobs really seriously. We have a lot of challenges, and to be able to call on our faith before each meeting, like this is just me talking, I believe that would set a very nice tone for the board that we have right now, and future boards can't speak for them. But in this time, with where we are, I could see it as being very beneficial.
Remember we had the guy came and did the inspiration not too long ago, Elena? He was like he had the little horn, and he was not, he wasn't a Christian, but it was some other faith, and he did his thing. He did the inspiration. It was, I think, Kelly, you may have been the chair, and it went well.
I think he might have been of the Jewish culture.
It was a different type of Jewish. Yeah.
Yes.
And
See, that would be,
We
that
had-
would kind of honor the religions that we have.
exactly, it was exposure. To me, it was
Yes.
exposure for our
Yes.
kids, that there are others that are different.
Yes.
So I didn't have an issue with that. And I'm the Baptist preacher on the platform. I didn't have an issue with it, so. But everybody's not like me. Yeah, exactly.
That's right.
And I'll,
Get it
yeah, I would also note that, that here we have, I just pulled up the United States Senate statement that I had heard before on this, and that's, the Senate does have a chaplain, which it starts all of its proceedings with. And
Yes.
Correct.
their statement that's on senate.gov on their website says that the office of Senate chaplain, throughout the years, the United States Senate has honored the historic separation of church and state, but not the separation of God and state. The first Senate meeting in New York City in 1789 elected the Reverend Samuel Provost, the Episcopal Bishop of New York, as its first chaplain. Since then, all sessions of the Senate have been opened with prayer, strongly affirming the Senate's faith in God as sovereign Lord of our nation. So I think
And they do it in Tallahassee too.
if federal guidelines are in opposition to that, I will research and find out and let you know.
Thank you.
Thank you.
Thank you, guys.
All right, can we move on to the next one then?
You can.
School visitors, that's 9150. These were Mr. McFadden's changes, right? There are some edits in here that have been submitted by our staff, and this is Mr. McFadden, in order to clarify and to limit some of this. For example, on the second paragraph, school visitors, at the very end of the second paragraph, it had said in the model policy to determine if the visitor is to be accompanied while on school property. And it's saying the principal also has the right to control the time of day and length of visit and to determine if visitors be accompanied while on school property. And what the basis of eliminating this is that we don't have unaccompanied visitors, truly unaccompanied visitors on school property at the determination of the principal anyway. So our visitors would be accompanied or within the line of sight or supervision of our employees at all times anyway. There's a deletion in the section regarding canines and service animals, because those are separately addressed.
I have just a quick question about it. It's actually up in the very first paragraph under school visitors, and it's the last line. And I was just wondering if there might be a different way to say this. It is necessary to invoke visitor controls. Lord.
Where are you at? I'm sorry. Oh, okay. I see it.
That just sounds really harsh. You know, invoke visitor regulations. Trying to think about.
Necessary to establish visitor regulations or?
Yeah.
Visitor protocols, anything.
Visitor protocols.
Establish visitor protocols.
I agree with that.
Okay.
Yes.
Yeah, because that just
Yes.
sounds so
Controlling.
penal. you
Negative.
know.
Controls.
Yes.
Like there's somebody
Establish
sitting
visitor
behind that.
protocols.
Yes. Visitor protocols.
Wrong hallway.
Yeah, you got to get buzzed in, you know. Yeah, somebody's in the big tower watching you.
Yes, that's how it's.
I will point out that our person that was reviewing this policy, you got a law enforcement guy.
Law enforcement,
Yes,
yeah,
that's
yeah.
He's invoking visitor
I see it. I
controls.
see
That's
it.
exactly what it sounded like.
Mr. McFadden, we picking at your,
That's right. Sorry, Dan.
We're trying to recruit visitors and volunteers,
yeah.
so.
Right.
You say you're going to get locked in when you get here.
Okay, so we made that edit on the fly here.
Excellent.
So it's necessary to establish visitor protocols. And then it does indicate there, the last
I got
line,
one. I got
all
one.
visitors must be supervised by school personnel while on school property in the second paragraph.
I got one.
Sorry?
Visitation by board members. Individual board members may visit a district school at any time. Board members may not be required, may not be required, may not be required. I
How
thought
about
they-
just
I
board
thought
members
they
are not
Are not
required?
required
Yeah,
to give prior notice.
because there was a big,
That's the statute.
yeah.
Yes.
But it says may not, meaning
No,
that,
no one may require is the point, but yes, are would fix it,
yeah.
Are not.
are not,
Okay.
right.
Are not required, yep.
Must
Is that what
sign
it's
in
be all the time
and
I'll be
sign
driving
out
on-
at school's
Give
main
it a
office.
B.
This is one of those situations where are, may, or must would all work to say the same thing, but are is probably the best way to say it.
And then I'm looking at it, says must sign in. I don't think we have to sign in, do we?
I think that's new, though, after, they want to know who's on campus.
I mean, yeah, but I mean,
Why wouldn't you want to sign in?
no, I don't have an issue with the sign in, but I don't remember that in the statute.
I think that's still required.
Is that
and
what you do?
I'd have to
Okay.
check the statute to see if it's required, but I can tell you that from a protocol standpoint,
I agree, I agree.
right. So I don't know that specifically whether statute requires, I don't know that statute goes that in-depth to say that a board member is required to sign in.
Because
just
that used
remember-
to be, sorry.
I just remember talking about this at FSBA, and they were like, you don't have to sign in. I don't have an issue with signing in, though. I don't have an issue with signing in.
All right, personally, yeah.
Yeah, and I find lots of times when you arrive on campus, I mean, sometimes they're at the gate and they're like, oh, sign in. Sometimes you bump into the principal right away and they're walking you
And
down
you're
a hall.
already gone.
And you're not signing in.
Exactly.
So, and it might be an afterthought. So I think the must could be iffy, because if you're running for office and
Yeah.
your opponent knows that you were on campus and didn't sign in, they're gonna be like, you don't even follow. That's how I think, though. I think I've probably been around enough to.
I'm thinking the same way, Ms.
Yeah,
King.
so if it's not statute, I mean, I think may be appropriate, because, I mean, I think,
Because you do know people track that type of stuff.
of course they do.
Well, and
call
then
the
it would be
school.
incumbent on the board members to make sure that they sign in when they get to a school. I mean, I'm the school board attorney, and I'm not a school board member, but
Yeah.
if I go to a school on even legal business to interview a witness or anything like that,
Let's
I'm
act-
still
let me-
expected to sign in at the front
Let me
desk.
play advocate. Let me play advocate. This morning, I was at 3 schools. You were too. Did we sign in?
Heck no.
Okay, exactly. So if it's not
Exactly.
statute with the must, I'm just thinking maybe more
Let me see whether
appropriate.
statute indicates that all school visitors,
The
in which
statute does-
case,
Mr. Wimmer's got it.
The statute does say must sign in.
Oh, well then,
Okay. Well,
is
if it
that
says
for
must.
board member
Everything.
specific?
Broke the
Okay.
law.
every time you go.
1,142.05.
Okay.
All right, there we go.
What year is that from, that statute?
2017.
2017. When was Marjorie Stoneman Douglas?
2018.
2018, interesting, because I feel like, as a courtesy now, because of safety, it is really important to try to remember to sign in and sign out.
Right.
But sometimes, like today, we were on a caravan, and
Right.
everybody knew we were coming, so it wasn't like the principals knew we were coming.
Right.
So it wasn't like we were unannounced.
Right.
So I think we were fine for today. But in general, I think that that's just really, not only is it courtesy, it's also statute, and I think it's a safety thing.
But it's just like Ms. King said, there's been many times you get to school
Oh, yeah.
and
they
you walk
grab
right
you
in and you're gone.
Right, or the receptionist is at lunch or something, and,
Yeah.
yeah.
I just don't want, I don't like to violate our own
Correct.
rules.
Right,
Yeah, and it's not intentional.
And-
no. No. And in the real world, or you might see someone that you were going to see that's, I don't know, headed out to the playground or something, oh, come see
Right.
my kids, and you're on campus, but you haven't even gone in the building yet.
Correct.
That's happened before. Although with the one entrance now, that's gonna get harder to do,
All right.
with the
So if the
fencing.
statute says must,
Yeah,
that just,
we have
that
to
needs to,
really
that
try
just
to
needs to
adhere to
stick in our
that.
head that we need to be
yeah,
very conscious of that must.
yep, okay, well,
I'm good.
says what it says.
Okay, moving into public attendance at school events, 9160. That begins on page 162 of your notebooks. Looks like a relatively minor, is this the first time this was brought? Okay, sorry. Yep, this is a NEOLA model policy. There is an edit that has been suggested here. and that is as to the third paragraph, no alcoholic beverage may be possessed, consumed, or distributed at any function sponsored, operated, and controlled by the district, or at any function occurring on board property, except for curricular purposes and with prior written consent from the superintendent and in compliance with Florida law, at any function sponsored by the district and/or at any function occurring on board property.
This is the one we talked about the last time.
Yes, so this is obviously the one that we reviewed before. So this is the proposed, back again from staff, edit that takes into account what staff's.
So.
Where does that leave us for social functions that are adult-oriented?
Okay, and Ms. Brown's indicating to me she doesn't recall getting
No.
any edits on it, so I don't know that this one has been edited. This is the green and underscored is not, where would that have, by
where we
operated and
landed?
controlled?
I think it just needs to be,
That-
oh,
I'm sorry, I couldn't hear, but Attorney Powers,
Well-
that's correct. We did not make any additional edits. The board was having this discussion before and was verifying. We did not,
Okay, so it was just brought back for us to reconsider. It was just,
because the board
Okay.
was having a conversation on this and its implications, so we did not make any.
Right, remember
Yes.
we recessed and then we kind of came back and we didn't deal with it.
Right.
because this is
Because the question was asked, the question
Yeah.
was, we've had events, in particular, the Golden Apple, which is what we were talking about, and we knew that there was, are we again, I'm going back, are we violating our own policies?
And so that operative third paragraph there, this is the point at which the board becomes, it's drafter here of the policy. So
Right.
this section, we have a few different ways that we can go about this. One is simply to say, as to specifically alcoholic beverage. Now, this, earlier on, and when we first got this policy, it also included other language regarding controlled substances, things like that, which just obviously are a no, unless it's, with a valid prescription possessed by that person for that intent and everything else. However, when it comes to the alcoholic beverage, we have 3 options that we can, well, possibly more options we can go with. One is to simply say, no, in all circumstances, under no circumstances whatsoever, do we allow a district-sponsored event, in connection with the Culinary Institute, or anything whatsoever, or anything that's sponsored by the district to have alcohol-related, or to have alcohol served, whether or not it's on school board property or anything else. That would be one extreme. And the other side would be to place something more like this, which is a bit broader, which is considerably broader, or to craft language in here that is going to cut and add or detract anything to take into situations that we already know of. For example, like a event which may be sponsored by the district and may or may not be on district property, but at which there may be alcohol served. Is there something that we need to address to keep in line with our policy, if this is going to be the policy? Or is there something we need to edit the policy to fit what we know is the real-world circumstance? So, with that, the board has the power to, the part of this that matters to me as your attorney is the in compliance with Florida law. And in compliance with Florida law, you're permitted to do a wide range of things. School-sponsored events, you don't have to limit those. You can, obviously, we know what Florida law says, and that is you're not going to be providing alcohol to students. You can't provide alcohol to anyone under legal age, and you can't, you can't generally have alcohol served within a school. However, there's a lot of leeway among district-sponsored events and culinary institutes and all sorts of things of that nature. Again, Florida law, I can make sure we're consistent with that. For curricular purposes, very good idea to have that language in there if you're going to have anything related to alcohol. And even if for curricular purposes, I think that if I were in the position of the superintendent, I would want, and I don't have to speak for her, but one of two things. Either that is, I would want it to be very clear that
It is allowed.
somebody's intention of, oh yes, I was doing that for a curricular purpose, has been approved by me. Or alternatively, I would want to stay completely out of it and say, don't ask me for written permission, because that would be something that creates a real nightmare sort of proposition for operations. So to seek written permission for a specific instance, which almost seems like you're making exceptions whenever someone asks. So that's the best I can give you. And now it's up to you to make some decisions.
Board members, what do you think? Kelly smile.
Well, my thoughts are I'd probably go either way. I can see why there may be times, like culinary or whatever, that there may be some
A
alcohol
recipe.
in a recipe. But there's probably a gazillion recipes, and maybe they could come up with another recipe that didn't include alcohol, So, and I'm thinking there's only one event that there may be, or in the past, there's been alcohol served, right? And that's the Golden Apple? Or maybe there's other.
It's the only one I know of. And it's never been on school grounds that I have attended or that I'm aware of. And is it
Yeah, it's
really a
not-
school-sponsored? Because it's,
Golden Apple.
yeah, and Public Ed Foundation plans all that. I know they're an arm of us, and we are connected, so.
The language that is here right now, as it stands, would require that in order for, it would give us the most flexibility in that if that event were moving forward, if it were sponsored, if it were operated, controlled, and sponsored by the district, it would still have to
Have superintendent's approval.
have to pass through the superintendent in order to have authorization to go through. Now, interestingly, it says, or at any function occurring on board property except for curricular purposes and with prior written consent. Now, I guess the question then becomes, is that an or an and? Because is Golden Apple, for example, for curricular purposes?
You're honoring teachers and
gonna
their
say they
curriculum
teach.
deliverers.
Sure.
Right, that's what I was
And
thinking
so
of.
that brings up my question. Is
Yeah.
it for curricular purposes, or is it just ancillary to those?
Yeah, it's a celebration. I guess I wonder about the liability for Dr. Gullett if she signed off on that and somebody, drank too much.
Premises liability, I'm not think is probably not that much of an issue because of the fact that in those scenarios, the premises liability toward the superintendent are no greater than the premises liability that would be covered by whatever indemnification policies or anything else we'd have to have in place for an alcohol-related venue to serve any alcohol, period. Which I can only presume that whomever is putting on such an event and the person, because as I understand it, it wouldn't be school employees or personnel who are serving alcoholic beverages. It would be someone who is serving them from
that venue.
This is a vendor?
Yeah.
The venue
The
But it's a
vendor
circle
would
square.
have those whatever premises liability was at issue.
Well, the curriculum, for academic purposes or whatever, such as in a culinary class, I kind of have an issue where, say we have a culinary class here, and they're gonna make bourbon chicken or whatever, and there's bourbon in there, one of the kids gets in it, and
They sponsored.
our kids get drunk. You know, kids are kids.
Event.
Where do we fall at with that?
And that wouldn't be
in
controlled by the
response to that?
Right.
You know,
Maybe the culinary teachers would know, you know, I don't even know how, if they're even using alcohol, because I think as a teacher, especially in this day and age, I'd be looking for the alternate recipe,
Well,
or
I know-
using a non-alcoholic something, I
well,
don't know.
I know they were using alcohol at our technical college.
Oh, at MTC?
Yes.
But I-
And, yes.
Yeah.
Well, and that was in keeping with Florida law, that even though that was a school, we sought to sort of clarify it here, but there is an exception within statute that defines what an alcoholic beverage is. And cooking sherry, for example, is specifically accepted as being outside the alcoholic beverage, as is vanilla. You know, vanilla has a
Extract.
high
Right.
concentration of alcohol.
Right.
So it's not that just any liquid containing alcohol, for example, hand sanitizers all over the place, ethyl alcohol, it's, you know,
Bananas have a lot of alcohol, in them,
so
believe it or not.
the fact is that, that it's, an alcoholic beverage is defined separately under Florida law, and that, so that didn't really implicate. However, in order to be really clear, they were also talking about the instances in which there might be, I think the example I was given was the French chef who is gonna talk about wine pairings with steak, and he's a world-class, what do they
Right.
call it, sommelier, you know, who's going to say,
Right.
here's how you do the wine pairings, and, you know, here,
Right.
those, in which case alcohol may be served to sort of test subjects in a cafe sort of scenario or environment or something like that. In which case, do we want to allow that if that were an opportunity? Or do we want a policy that says we can't allow it? Or that it would be allowed because it's for curricular purposes and within the superintendent's discretion if they specifically got it signed off on? I think the purpose of saying within superintendent's discretion was to ensure that it was not someone else making that call who may think they were authorized to do so, but is not. So it's
So
not
it's more-
broadening this to every staff member deciding whether it's for a curricular purpose.
So it's more to inform the it's for notification so that that superintendent knows that this action is going on. The serving of alcohol, that's what you're saying?
It would certainly have that effect,
Okay.
yes. But I
Superintendent, how do you feel
I don't
about
want to
that?
I'm probably
that's accurate.
over-guiding this as is, so I'll be
No,
happy
that's
to
perfectly
be quiet
fine.
and
We
let
we did have this
superintendent- fine.
extended conversation. Thank you, Attorney Powers. I think the curricular piece, we did talk about the cooking sherry, and as it pertains to more of the post-secondary opportunities beyond 12th grade, right, to the college students. Now, as we increase dual enrollment, that presents another set of challenges.
Right.
Right, for those students who might attend. I do have, I had to throw something in here, but a question for the board to consider. When you look at this language, I'm thinking of not just our Golden Apple celebration, but let's say a school has a PTA or another organization, they want to do an evening event. And it's under the umbrella of being a function, and maybe off campus, but it's school-related, involves staff. What does that look like?
And you know what?
Fundraisers, things.
Thank you. You just jogged my memory. There was a school that did a raffle, high school. And the raffle was a basket of liquor, and it was on campus. So did we,
Or they have an event off campus, and
Right.
it's an adult evening to raise money for the
Right.
school, but it's not, perhaps there's a business partner sponsoring it, but it's school-related, and the money.
Right.
I just think clarity is going to be important for our district in this.
Yeah.
Because I certainly can tell you as a superintendent, I don't want to be the one saying, no, you can do this, you can't do that. I think that there certainly could be some well-placed argument for it's going to back to help our students, but I think we have to draw a very clear line on this
Yes.
for the benefit
Yes.
of all.
Yeah, well, I think about, okay, the bourbon chicken example. That doesn't mean that you bring in, a handle of Jim Beam if all you need is a half a cup. Because kids will be kids, and if it gets set off to the side, then maybe the rest of it will disappear. So again, there's some common sense around this, too.
Or property. It's
Yeah.
kind of redundant.
And maybe you measured up at home if you're the teacher and bring just what you need for the recipe sort of thing.
Well,
I would advise against that, because then you've got
Yeah.
an open container of alcohol being transported, which is against
Right.
state law.
open container.
Oh, geez.
No, can't do that.
I'm not good at this.
Yeah. Yeah,
I'm not comfortable with that.
I'd rather
Trying
not
to
to come
create
from,
opportunities while breaking.
I'd rather not to come from their private stock that they brewed it in their backyard too. So-
Well, and the fact is, whether it's a 1
I haven't
ounce,
gotten to brownies yet.
whether it's a 1 ounce container that is sealed, that is specifically for
Right.
an entire recipe,
Right,
or it's the giant jug,
Right.
the amount really doesn't come into play unless we say it does, unless we say up to 4 ounces is permissible. I mean, we can't really do that either, I mean, you could,
I was just trying to think of,
but, I mean, yeah, the common sense, but then where do you draw the actual line and say that this amount's okay and that's not?
for me, as for cooking purpose, culinary, I understand it. I do understand it. I think that needs to be limited to high school only. There should be some safety protocols in place on, what's on campus and where is it located on campus, and who has access to that alcohol on campus. And it should never just be in the hands of a student, because then we're contributing to the delinquency of a minor by just putting it in their hands and saying, hey, go measure this. What's the probability of that happening? It's highly likely that it could happen. Just, go measure this, and 1 for you and 2 for me, I think there's
Let me start by suggesting that as we tackle what you're suggesting right now, the language we've got here, that what we've just highlighted in blue is clearly redundant because it's already stated in the first part. So unless anybody sees any reason to keep that, we know that that has to go anyway.
right.
And then we can deal with, so that perhaps it's less confusing when we try to structure the framework of what you're talking about now. We know that at least getting rid of that might help with some clarity, and then we can decide what to build on and what to take away.
Would we keep this statute reference?
No, because we say in compliance with Florida law,
Okay.
which 562.20 is the one that is identified here, but just in general, Florida law, period. Mr. Whitmer, do you see any reason that we should specifically cite 562.20?
No, it's where is 56-220? Oh, yeah. Except it's otherwise defined. That was not a NEOLA addition, so it was taken away.
And I think that the reason that it is likely to be there is 562.20, monthly reports by common and other carriers of beverages required. All common carriers of freight operating in the state shall file monthly reports, which shall show in detail all shipments of alcoholic beverages being transported by them or to or from any point within the state. And this is talking about shipping Such report shall show in detail the name of the shipper, consignee of each shipment, description and kind of amount of each such shipment shall be filed monthly.
It doesn't have any bearing.
I don't think that, I thought that perhaps why it was in there was there might be some circumstance or scenario in which state requires a very specific kind of record keeping, but it does not appear that this is applicable. So I would probably, yeah, I just don't think it's applicable. I think we just end with a period at Florida law. And then we start from there and go back to the beginning of the paragraph and say, does that state, how do we want to alter that statement? No alcoholic beverage may be possessed, consumed, or distributed at any function sponsored, operated, and controlled by the district. Now, keeping in mind that if we use an and there, a conjunctive and, that it has to be all three.
Right.
So, if an event is sponsored but not operated or controlled, then this prohibition is off. It's not, we don't have, this policy doesn't control. If it's controlled by us,
But sponsored by someone
but
else?
sponsored by someone else, well, I guess if it's controlled by us, it's really being sponsored by us as well, because we're, sponsored, let me get your input, Mr. Whitmer, as to whether you think the conjunctive and is appropriate there or not. Any function sponsored, operated, and controlled by the district. So that would indicate that for this policy, that portion of the policy to be taking effect, all three have to apply.
Well, some districts have events that are like teacher recognition, that are sponsored by a foundation, for example. And maybe held at a different venue from any school property. And that would permit alcohol service, maybe.
So my question would be, is the foundation technically a part? We pay
Correct.
employees over there. don't we?
Correct.
So
We
that's,
we are already, yes,
yes, okay.
supporting positions. So ours is inclusive of our
Yeah.
district. It's not a distinct, separate entity. So we are paying for staff
Yeah.
at the
So our
Public
foundation is
Education
not separate
Foundation.
from the district.
So thereby, my question would be, at any point, anything they do is at least partially sponsored
Right.
or controlled by or operated by, at any point,
They're
at any
not- are they
event. Even if
separate
there's a
from-
business partner involved, we are still partially involved in each of these.
Are they a separate 501c3 organization? I wonder if they are. I mean, are deductions are tax deductible and
I don't think
yeah.
so.
donations? They might have
Donations are definitely
enough
tax
separation if they're organized that way.
I wouldn't be comfortable with that I wouldn't be comfortable. Even though that is, you may well be, you may be correct on that. I wouldn't be comfortable with that distinction being something that staff is taking into account to determine whether something is permissible or not.
Correct.
I would want
Correct.
for us in a form of policy to simply say yes or no. I believe it is
Agree.
sufficient for us to say sponsored, operated, and controlled by the district. So that means that the unintended consequence, if we said the or, would be if we sponsor an event, but we're one of many sponsors, and that event is to recognize firefighters. And as part of that event, they do have wine with dinner or something. It's not on school board property. We're just a sponsor. We're one of 10. Or a golf tournament. We sponsor a golf, I mean, I don't know, we may be prohibited from doing those things anyway. But the fact is that if we sponsor something we have to consider whether or not they, outside of our sponsorship, may within their venue consume alcohol. I don't necessarily know that that's our purview. But secondly, putting that language sponsored, operated, and controlled together indicates this is clearly something we're putting on. And I think something that the Public Education Foundation is putting on is something, for all intents and purposes, that we are putting on. Or at any function occurring on board property. So whether or not we're putting it on, if it's being on board property, people rent our spaces for things. And I think that it is appropriate for us to choose, if we so choose, to disallow people from serving alcohol on our property when they're renting our property. And again, all of these are subject to, if there's a curricular purpose and the superintendent agrees with prior written consent, they can do it. And that's the element that I would say that is sort of the backup protective layer if the superintendent wishes to take that on. But I don't know that that's open for discussion.
And if I may, again, I'm going to use, so the Golden Apple is a clear example, but I'm going to think of other examples again. A PTA function, any other parent organization function under the umbrella of a school or a district that may come up. How far are we going to support that? What are our allowances for that? Because I do not believe I could adequately control that, nor can my team. So I think there needs to be clear language to
Right, and
protect
I
our
think-
district and
I
our
agree.
employees from doing something that might be outside the scope of what we would intend.
And I agree that I think that the headline and the starting point here is, and perhaps even by formatting, we might be able to clarify that more. Starting point is no. Next point would be, it's no if it's if it's someplace it's operated, controlled, or sponsored by the district, or if it's on district property. Your answer is no. Unless it's for curricular purposes and with prior written consent. And those would have to, the only cases in which that would apply would be things that as a, I mean, your answer as a superintendent could be no across the board, with the exception of something specific that meets the sort of exemption like the MTI, or not MTI, but the Marion Technical College culinary, or Golden Apple, or something like that. Or I might also suggest that a possibility that we could take whatever criteria we're meaning to fit those two and write that criteria into policy. I just don't know how exactly we do that. Because we know that I'm assuming that what I'm hearing is that it'd be nice to be able to have the culinary exception written in if it were under some sort of procedure, carefully crafted and carefully monitored. And that overall, we'd like to be able to do things like Golden Apple as they have been done. If those things are true, then we can either write those into policy, or we can say that those are going to be examples of the extremely rare exception that gets superintendent's approval.
And if I may speak to the curricular piece, I think the procedures could be very clear to say an easy solution is they're in a locked cabinet. So that's an easy thing to do procedurally, to address that.
Yeah,
I can go for that.
yeah.
Yeah, and I just, you mentioned high school. I'm not even sure it should be in high school. I was thinking MTC, like the wine, the culinary. I don't know if the high school, because what Dr. Gullett stated very early on is what's best for students.
Right.
And I'm like, we're having a lot of discussion over alcohol, and all our students, most of them are 18 and under, and I'm thinking there's a lot of discussion over
Well, and we do have
This.
students who are under the age of 18 at Marion Technical College, and we have students who are in dual enrollment programs who leave our schools, get credit from our, schools, and they're going and participating in activities that, at a college that may,
Yeah, but I mean, but we're talking cooking. Like, I can think of a lot of recipes that do not include alcohol as a rule. So I'm like, is this really what we want to, the more I think about this, like, is this, I'm not, I know it cooks out or whatever, but in my mind, I'm kind of like, is it really necessary? Is it a necessity? Is it make a difference on what they, maybe a culinary, like, maybe MTC, maybe they would. I don't know enough about it. That's a NEOLA template. But those are just, the more I think about it. And as
Well,
far
and-
as like the foundation, like what if they have the, like say at the Riley Center or whatever, and they serve it, but if the people that want to celebrate want to purchase their own drink, then I think that takes it out of the schools, right? Out of our liability. Am I
Well-
right on this or no?
Well, it's not, yeah, and it wouldn't be a matter of our liability, but if it's held at some other place, like, I don't know, the Riley or some other venue,
If it's a sponsor.
but if it's sponsored by us, then even the possession or consumption by anyone.
But if
is-
it's sponsored, well, then if, I could take this further, because think about everyone that goes away on, when we're sponsoring teachers going and learning about new curriculum or something, and they go to the hotel bar and then they purchase drinks. Are we responsible then? Are we sponsoring that? And then, but my point was with the foundation, they could purchase their own drinks if they want to, but the district isn't purchasing the alcohol. Does that make sense? So does that still fall under that purview, like of?
Great question, Ms.
Do you
King.
see what I'm saying?
Great
Because I'm like,
question. What about if you go to a conference and there's a
when they're at
reception?
conferences, correct. But we're paying for them to go,
We're
you
paying for
know,
them to go to that.
So that's what I'm just thinking about that.
Well, we're paying for them to go to the conference, but it's not operated or controlled by us.
Right. So the Riley is not operated or controlled by us. If we're renting it, we rent it.
Well, the venue, it's not occurring on school board property, which is the second half of that. But if we are renting out the Riley or some other venue which does serve alcohol, and I don't know if the Riley does or not, I have no idea, but,
Yes.
They do.
okay, if they do serve alcohol, but we're renting it out for our purposes, then it's a function that is sponsored, operated, and controlled by the district. So that would be, that's part one. And then part two is, it would be clear that regardless of whether we're running it or somebody else is renting from us, they can't, we have a hard no on district property. So if this stage and auditorium, we're having a theater night or something, they can't serve champagne out there under any circumstances. Unless, for some strange circumstance, it were for curricular purposes and with prior written consent of the superintendent, which isn't gonna happen, and it's not, be hard to envision a curricular purpose there for the serving of champagne. So,
I guess when you say all this, I just keep seeing different scenarios. I see a retirement celebration, someone having champagne at the retirement celebration, it's their last day of school or whatever. I just see so many different scenarios in this, and we can't play all the scenarios out in our head or even in this, but I think we have to come up with something that's going to be the safest and most
well, the hard stop would simply be to say, no alcoholic beverage may be possessed, consumed, or distributed at any function sponsored, operated, and controlled by the district, or at any function occurring on board property, period. And leave off any exceptions, so that we simply say that, no, if it's an event occurring on school board property, or if, whether or not it's on school board property, if it is an event that is sponsored, operated, and controlled by the district, which would include Golden Apple, if it's by the Public Education Foundation, then, sorry, they've got to change their way of doing things. So that's the clearest we can possibly be. But the clearest we can possibly be doesn't take into account, some things that might possibly be wanted. And the question is, well, is it, like Ms. King said, is it really that important to this board whether we allot for culinary use of alcohol? Maybe it's not. And if Golden Apple is really kind of one of the few or only outlier to this policy, do we need to consider an alteration in that, alcohol being served at an event like that?
I'd like to hear what the culinary teachers have to say, how much are they really using it, I really don't know the answer to that question, and I think about, no alcoholic beverage may be possessed, consumed, or distributed at any function occurring on school board property, except for curricular purposes, and maybe not even that. If it's really not a deal breaker for kids to be learning how to cook, then to me that just, why have it in there? It's creating more problems. But if we have a function that's not taking place on school board property, like the Golden Apple, then it would be able to continue as it is, right?
Right, so if we deleted, I think what I'm following you to say is that if we deleted the function language and said, we're gonna leave that completely silent, we're gonna remain silent on the type of function it may be, but simply talk about what happens on our property, then the statement would say, no alcoholic beverage may be possessed, consumed, or distributed at any function occurring on board property, period.
Right.
And then that gets rid of, now that would get rid of the culinary, unless we left that other part in, except for curricular purposes.
Right, and I would like to have more clarification on that. I mean, is it an issue or not when it comes to teaching kids to cook? And if it isn't, then why have it in there? Because it's creating all these what-if scenarios. And if it is, then maybe the lock cabinet and all that, there'd be procedures around it.
But by deleting the sponsored by the district or in any function language, that removes from consideration anything about stuff like Golden Apple.
Right.
And so that's a non-issue. So that would mean then, though, that if any event that is, any function that is sponsored by us, sponsored by the district, that alcohol could be served.
As long as it's not on school board property.
As long as it's not on our property.
That, to me, would be the balance, striking a balance. But I don't drink at those things, so I don't have a dog in this fight, but I'm just thinking about tradition, and
You're like me, I don't have a dog in that fight either.
you have an Arnold Palmer.
Yeah, that's my drink, the Arnold Palmer.
I don't know, how do you guys feel about that?
Yeah, I'm indifferent either way. I think we're just spending a lot of time on alcohol, really, and I'm like, I'm not really sure why it's that significant, if that makes sense.
Adults, when they get together at Golden Apple, they like to have a drink.
I mean, I can understand that, but I don't know.
I don't want to be.
It's public education. I mean, it's teachers, sometimes you're just held to a different standard
Yeah, and
than.
nobody's saying that you should have to be
going-
carried out of the function.
Well, yeah, I'm not saying that.
Do we, my next question then, that might be able to resolve this now. No alcoholic beverage may be possessed, consumed, or distributed at any function occurring on board property. We can draw a period there and be done with it. Or, as you had indicated, Ms. Thrower, if we want to take this time and reach out to Marion Technical College staff and see to what degree that this impacts them at all, or superintendent can make an executive decision on what she would like to recommend. That's up to you.
I've reached out to Mr. Kelly for the record.
There we go.
So I've already texted him, haven't heard back yet.
Yeah.
She's always 3 steps ahead of us.
Of course, because we're looking
Mere
at
mortals.
expanding our career and technical education, so
Right.
we certainly don't want to hamstring ourselves.
No, we don't.
Right.
But at the same time, if it's really not a big deal, then it's probably better as much as possible, especially for the kids that might not even be old enough, you know, that are under 21, to not even have it. But that is a little overpowering when you think of cooking sherry and a splash of this. I mean, geez.
And I don't want to hamstring the foundation either.
Right.
A lot of times the foundation, we get donations.
Right.
You know, our community partners put together that event.
We left that open.
So,
Yeah, we love
We
it.
left
That
the
would leave that
foundation-
open, right?
We left that open.
Yeah.
Yeah.
That leaves
So
that
it's
open.
really just the
okay,
implication of academics.
okay. I don't have an issue as long as it's properly handled,
It's always the goal.
sealed, yeah.
And so far it has. That's, I mean, there's
Yeah.
nothing that's been brought to my attention that has made me think that maybe there has been some things.
It's
We'll
always
get more information. We'll move forward.
Well, we'll hear back from Dr. Gullett on the
Yeah.
culinary program.
Can we bring that, can we come back to that one?
Sure. And for right now, though, we are in agreement that as to the specific, as to the
First part.
first part of that, that the edit, no alcoholic beverage may be possessed, consumed, or distributed at any function occurring on board property,
Period.
deleting the sponsored by the district or at any function language. Okay. Now, that will come with a hard period after property unless Marion Technical College comes back and lets us know that there is some need for some limited exception within their culinary program, in which case we will leave the language except for curricular purposes and with prior written consent from the superintendent and in compliance with Florida law? Or talk about it later?
We certainly could, or we could specifically state under those conditions, Marion Technical College. I mean, we wouldn't even have to call the school, but
All right.
we could describe that.
So here's what I would propose. What I would propose is that if we get the answer back from Marion Technical College and the superintendent that indicates that Marion Technical College says there's not a need, and we identified no other curricular need for it, then we just pass this one straight through the clean folder with no alcoholic beverage may be possessed, consumed, or distributed at any function occurring on board property, period, and we're done. However, if we do get something indicating that there is a need for it for a curricular purpose, or we want to leave that exemption open, it'll be brought back before you at our March session. That work?
Works for me.
I like bourbon chicken. And I like
Well,
rum,
and,
and I like rum cake, so.
Yeah, and if we're gonna check with MTC, you know, MTI cooks.
Yes.
You know,
Yes.
let's check our high schools,
Yes.
Denellen
Yes.
and Forest, so I think it's important
Yes,
to
absolutely.
see how it impacts them, or
Okay.
not. Okay,
Thank you.
Thank you, guys.
So you'll put the notes that that one may be brought forward again? Okay, and if not, we'll put it in clean.
Alcohol always has a way about causing conversation, doesn't it?
That's why.
Well, many words spoken, fewer words written. That
Yes.
makes it when you get the policies that are very, very long written, then it leaves way too much room for interpretation.
Yeah. I thought it only made you talk when you were drunk, but apparently it makes you talk when you're sober too. Because we've been talking for about an hour on this one.
Let's see.
Relations with
Relations
special.
with Special Interest Groups, PO 9700. This is on page 164. I think is this the first time up on this one?
I think we got through them all last time, and these are just minor edits.
Okay, so these should be minor edits here because it was, there's a change in the second paragraph from board to superintendent. And superintendent means designee, so we probably don't need that language, right? So let's delete designee. And please, stop me if that, anything I'm saying you need to add anything additional to. Producing or disseminating to the community is really kind of a redundant, so they eliminated that. Just said producing or disseminating, that's in paragraph, third paragraph of A. And the term distribute campaign literature, and we said literature may be a little obsolete, that it also should include material.
Material.
Largely.
Correct.
Because sometimes the definition of what is literature may not be as inclusive as we want it to be.
Correct.
You can see the remaining few strike-throughs. If anyone wants to address or bring up any one of those, you may. Otherwise, if they meet with your approval, we can move forward.
I'm okay with it.
Me too.
Okay. Moving on to 9800 charter schools, which begins on 168. Mr. Whitmer, where were we on this one?
We never got to this one before?
This is the longest NEOLA policy. And it gets renewed every year updated because
So what you have in front of you here, this NEOLA policy as to charter schools, this updated policy, this is NEOLA's update, it should take into account or does take into account, I should say, all current Florida law regarding
Charter schools.
charter schools. As you can see from page 167, there are more than a dozen, probably 15 or more references to Florida statute. And then many to the Florida Administrative Code and to Florida Department of Education forms. Now, there was one edit that we looked at and made regarding this to this policy, and that was on page, let's see, can you identify the section right away?
There's one instance where it said chatter instead of charter.
And it was a scrivener's error, charter instead of chatter. It said chatter, should say charter. So we made the fix and it was done. So, because it's a single letter, it's hard, it's tough to find where the revision actually was, but, oh, I think you passed it. Anyway. Yep, gotcha. So that was the only edit that had been made by, because staff reviewed, and only edit that was made by staff.
It would have been seniors, but it wasn't him that called.
All right.
And this is one where now with the changes in state statute, it's not just us that gets to.
Right, and in fact, this is a superior version to anything we've had so far.
Okay.
And this version would be taking into account everything that is the most updated as far as regulation of charter schools. There's not much philosophical in here, not much that's decision-oriented or decision-based as to what we can or should or ought to do. This is more about the governance of running a charter school and how it interacts and intersects with us as a public school, which is extremely driven by statute and Florida Administrative Code.
Right.
So unless anyone sees any particular area they want further description of or something from input from staff on, then we can be completed with this particular policy as well.
I have just a quick question, and I don't know that it would be covered in here, but because I'm very familiar with the process of even district charter schools coming to us with permission to start a charter school. But can our district, can our school board initiate a charter school? Like our own district charter school, if we wanted to create one?
If I had that question, I would immediately pick up the phone to my charter school expert, who is Mr. Stephen Ayers. And I would say, point me to the statutes regarding this particular issue, and then I would figure out exactly under what circumstances we could and might not be able to.
Right.
But I believe that the answer in that is yes, we can. We have certain guidelines we have to follow. I just don't know what those guidelines in particular are.
You mean like one, are you talking about on one particular, just one pilot school, or are you talking about district being charter
No,
school?
I'm talking about individual ones, for example, because we're so constrained by the fish report. You know, we have seats in our north end schools, but we have no seats in our
Am I right
southern
on that,
end
Mr. Whitman?
schools. So
Okay.
would that be a workaround? We would start our own charter school, but it'd be a district-run charter school, and we put it on property that we already own. And then maybe they would pay for it with PICO funds.
We could just flip it all, actually. We could become a whole district be charter school, and then we have the land.
We'd have the
And
money.
we have the money, we wouldn't have all the mandates.
Right. That's where I'm going. I mean, if we're gonna have the rules.
You're gonna
be in
wait
the law,
until your school board attorney retires, right?
we might as well. That's all about,
I
that's
think
just,
we need to have the conversation.
isn't that what this is?
No. I mean, I think we really need to have that.
Yes.
That's something
Sooner
that
the
we definitely
better.
need to have the conversation.
Mr. Whitmer is verifying that, yes, I'm correct, that we can, that it is called a conversion charter school when the board, and the board does it. When the board does it, it's called a conversion charter school. And there are specific Florida statutes on point as to exactly how you go about doing it, so.
I would love to know more about this.
So stay tuned, guys. It's ironic that y'all brought that up. I kind of mentioned that to the superintendent yesterday.
I think it's been in all of our minds because we're all frustrated at the fact that, right now, we're just not getting the resources that we need in terms of, especially in terms of capital investment, and it's a problem. But problems wouldn't be problems if they didn't have solutions.
And Attorney Whitmer, are you referring to the turnaround option plan provisions that are already in place for the district to,
That's another one, there's one
Yes,
district in the state that's gone through that,
so, yes, 'cause
In this state,
that's,
in this state.
This-
and they had
yes.
some bad
yeah,
outcomes.
conversion for that.
I like more what you're talking about versus an entire district, especially this district, being charter, because honestly, we're too big for one charter to run our whole district.
No, I was alluding more to, I was alluding completely to the fact that we know we have known overcrowding
Right.
in the south end, and yet we haven't been able to do anything about it.
Right.
So that is my incentive and always has been. That's where I am.
Right. And it's good conversation. Jefferson, the county that he's talking about is Jefferson County.
Right. No, I don't think we really want to model anything after that disaster, do we?
No,
I don't.
no. There's some issues with that,
Yeah.
that model. So, Any,
All right, having concluded that one, I can give us a little bit of, Chair Cummings, if it's acceptable to you, I can give a little bit of a preview of what we'll be doing next.
I'm ready. We're ready.
Okay. Our next sessions that we have are set for, let's see, March 29th. March 29th is going to be bylaws. And we will, as we've done with the board here, and I say we loosely because honestly, Terry and Keishla, Ms. Brown as well, have put a whole lot of effort in getting this book together. They'll have those for you on the bylaws so that when we meet at March 29th at 9:00 a.m., we will have review of bylaws. Then, let's see, on March 30th at 9:00 a.m., we will be running into any remaining final policies to be brought back before the board of the 5 or 6 here that we have discussed. We already have those, plus there's a couple of backup, I think at this point. We're looking between 8 and 10 total policies that should have at least some discussion or some brought forth for approval. And that will be on the 30th. Because I think 4 to 6 of those are ones that we are actually bringing back with operative things we've done here. And then we have 5 or 6 that are updates from NEOLA that'll be submitted for your review and approval. And that should be all. We'll get any materials that the board needs in order to review those as soon as possible. If for any reason there are any outstanding policies that have not yet been addressed, or we find an emergency error or something that we need to fix, I would just ask that everyone from staff look into any other change, not to invite changes, but any other change that might be necessary. If we can have that to my office by March 1st, that gives me plenty of room to get it cleaned, get it submitted to NEOLA, get them to take care of it, and have any final edits uploaded as well. Okay.
Chair, if I may, Attorney Powers, could you review the items, the numbers that you need information on, so we can make sure that we all have the same numbers?
The items that I need information on?
Yeah, policies, the policies. I think
Oh,
Terry
yes.
has a list.
5460 and 5451, 5610.05. Then the one that we discussed earlier, Dr. Gullett, 1113 and 6610, how those interact with each other.
Yes.
Ms. Gary is working on 1362, 3362, and 4362 in inserting the core from NEOLA's update of 5517. So those 4 are all kind of together.
And
Then,
go ahead.
sorry.
No, continue.
8800, that's the redraft of the diploma issues. Is this the one? 8800? Oh, 8800 is the religion, I'm sorry. 8800, religious observance, which is, I'll be working on. And 9160, we're waiting to hear from culinary.
Correct. My only note here is 5460 that you referenced, graduation, that was already resolved. That was the diploma. We're going to bring back feedback on 5451.
Right, yes. So
Is that correct?
5460, I believe that that what we addressed today, we did leave that language in. I'll double check that.
That was my understanding. Okay,
But as to diploma, we said full legal name.
correct. So
and
5451 would be the one that we're bringing
5451
back.
would be the
Yes.
one that we need to decide on, which may then result in some alteration of 5460 based on what the board decides.
Thank you.
Anything else? Yes, ma'am, Ms. Story?
Yes, Chair, since it seems to be in your mind too, what would be your thoughts on maybe adding a work session item so that Mr. Ayers could come in and talk to us about the district, you know, a specific district charter school option to reduce overcrowding?
Already done.
Oh, it's on there? It's
When
coming?
did we talk, Superintendent?
See there?
Yes, thank you, Chair. We did on the March 3rd work session, we are going to have the annual reports by charter schools. If the board so chooses, we can add it as a separate item and notice as such. Otherwise, Mr. Ayers will be here to talk about and to provide an update on the reports by charter schools. However you wish to proceed, but he will be here to do that.
Right. I had this conversation about that same discussion, and I asked that it kind of be added to the end of that.
Oh, great, okay.
All right.
Awesome,
So we're kind of on the same page.
you bet.
All right.
That makes me happy.
Ms. Martinez Lopez, any comments?
No, sir, thank you.
Thank you. Superintendent?
No, thank you.
All right. Mr. Whitmer?
I'm just glad we're making progress.
Terry?
I think that's what it is.
Attorney Powers?
I think I've said enough for today. Thank you, sir.
Ms. King?
I just want to thank everybody for their hard work. This hasn't been an easy task, and we'll keep on chugging along. And also today, I have on my Bo Leave shirt because we have our hometown hero, Brittany Bowe, who will be racing early in the morning at 3:30. So we had her spirit. Her mama, Debbie Bowe, was a teacher, or actually a guidance counselor at Lake Weir High. And also last week, or over the weekend, our own Erin Jackson, who is a Forest High graduate. She's a gold medalist. Brittany's a gold, and we're expecting or praying that she gets another gold tonight. So
Yes.
just had to put out a little plug for her that we're so proud of her.
Yes, we
So,
are.
Yes.
and that's all I have. Thank you.
Thank you, Ms. King. Ms. Thor?
I concur 100% with what Board Member King just said. Go USA.
USA.
And I concur as well. Go Team USA. We are going to be adjourning this meeting at 3:56 p.m. Thank you guys for the hard work, all that's put this together. Superintendent, your team, everyone that's making sure that we get through this. I'm starting to see a little bit more light at the end of the tunnel, that we may get through this. So we will get through it, not may. We will. We learned there's a difference between may and will. So
We shall. We shall overcome.
we shall
Not we
get
may
through this.
overcome,
We shall
That's right.
overcome. Thank you, guys. Meeting adjourned at 3:57.